Good morning. Welcome to Webb County Court at Law 2. I'm Victor Villarreal, judge of your Webb County Court at Law 2. This is the family law docket for Wednesday, January 28th, 2026. The time is now 9:45. Court is now in session. Assisting us today are Cecia Rodriguez, court administrator and interpreter. Ms. Cynthia Flores is the family law court coordinator. Video conference co-hosts this morning include Ms. Reyes, Mr. Cordova, Ms. Cuellar, Mr. Hernandez, and Ms. Ramos. These proceedings are being electronically recorded. Everyone is instructed not to record any portion of these proceedings. Only a court reporter may provide the official record. As with all proceedings, violation of these instructions are subject to contempt hearings. If you're joining us online, you're instructed to act as though you were in court because you are in court. The rule here is simple. If you would not do it in person, don't do it online. For example, do not operate a motor vehicle. There is no smoking, no chewing gum, wear appropriate clothing, and always exercise proper courtroom decorum. The court will now call the cases in the order of appearance of counsel, first those in person and then those online as measured by your login times. Ms. Flores.
Yes, Your Honor. First case in person would be Attorney Jose Loredo, standing in for David Gonzalez, page 5, number 14.
Jesse James Ortiz Jr. versus Leilani Ruby Ortiz, cause number 2025 FLA 1577C3. Good morning, Mr. Loredo.
Good morning, Judge.
Court marks you present in person. Are you speaking to the microphone and tell the court, are you Jesse James Ortiz Jr.?
Yes, sir.
Welcome to court, Mr. Ortiz. The court marks you present in person. The person to your left is your lawyer. Good morning, Mr. Martinez King.
Good morning, Judge Villarreal.
Good morning. Court marks you present. You're participating by video conference. Leilani Ortiz, are you present?
We advised her that she wouldn't have to be present on this due to our conversation with the opposing counsel.
Court marks Ms. Ortiz not present. Mr. Loredo, Mr. King, what is the announcement?
Yes, Your Honor. We would like to request a continuance on this case. We are close to finalizing the final divorce. I believe it was just the pending matters of some holidays and the child support, Your Honor.
All right. This is a first setting by policy. The court grants first setting. And this is also, I believe, Mr. Martinez King's first appearance. For all these reasons, well taken. Ms. Flores, give us another trial with the last trial on merit date, please.
March 5th at 9 a.m.
Mr. Ortiz, do you have any questions for the court?
No, sir.
Keep in contact with your lawyer between now and March the 5th, and I look forward to concluding your and Leilani's case. I wish you well.
Sir, thank you.
Anything else for any other cases for Mr. Loredo?
That is all, Your Honor.
Have
That's
a
all I
great
had, Your
day.
Honor. Thank you.
Next case is Attorney Eduardo Romero, page 1, number 2.
Luis Javier Flores versus Ana Cristina Garza, cause number 2020 FLB 1698C3. Court marks Mr. Romero present in person. Luis Javier Flores, are you present? Court marks Mr. Flores.
Yes, I'm here.
Court marks Mr. Flores present and participating by video conference. Good morning, Mr. Flores. As you can see and hear, your lawyer is present in person. Speak up once more, Mr. Flores.
Yes, I'm here, present.
All right, welcome to court once more. Court marks Ms. Leticia Garcia present and participating by video conference. Good morning, Ms. Garcia.
Good morning, Judge.
Is this Ms. Garza on your right?
It is, Judge.
Welcome to court, Ms. Garza. The court marks you present participating by video conference from the office of your lawyer, and court also welcomes Ms. Elisa Marsoto, who is the court's appointed guardian ad litem. Welcome all. Mr. Romero, Ms. Garcia, what is the announcement?
Your Honor, I submitted some financial information to Ms. Garcia, I believe it was Monday. She is in the process of reviewing it with her client. As soon as she does that, I believe that we can finalize the order, Your Honor. So I would respectfully request for just maybe a few weeks, Your Honor, so we can hopefully submit that to the court.
So before I hear from Ms. Garcia, what you're indicating to the court is that it's just a matter of making some calculations to effectuate the final agreed decree?
Yes, sir. Well, not decree, an order on a modification, Your Honor.
It's a petition to modify. You're right.
Yes, sir.
Ms.
That's
Garcia.
correct, Your Honor. It took Mr. Flores a bit to file the last year's income tax return, but thankfully he did so. It's somewhat long. It's about 10, 12 pages long. I haven't yet seen it as it came in 2 nights ago, but that's correct what Mr. Romero states. We should be having an agreed order in the next couple of weeks, Judge. If we can just have that period of time, we can work it up.
Thank you, Ms. Garcia. Ms. Soto.
That's correct, Your Honor. That's what the parties advised me of. I'm still here. They already have my reported recommendation for visits. If they need additional assistance, they're free to let me know so that I can work on with them on a proposed visitation order.
Sure. This is a fifth setting, but it sounds great that you're close to finalizing. So let's do this. Ms. Flores, give me 3 dates. Give me the final hearing and petition to modify date. One more. That would be the 6th.
That'll be March 5th at 2 p.m. And I'm sorry, March 5th at 9 a.m.
At 9 a.m. And then give the court an order's due date.
In February, Your Honor,
No. So after March the 5th?
that'll be March the 30th at noon by submission.
And then give the court a dismissal date after that.
April 16th at 2 p.m.
All right. So there it is. If you need a hearing, I'll hear it on March the 5th, but you can enter in those orders anytime before then. They're actually due by March the 30th. Dismissal won't be necessary in April. Anything else on this case, Mr. Romero?
No, Your Honor.
Ms. Garcia?
No, Judge, not on this one.
Ms. Soto?
No, Your Honor.
Mr. Flores, unmute your device and tell the court if you have any questions.
No.
Ms. Garza, do you have any questions?
No, sir.
Ms. Garza and Mr. Flores, keep in contact with your lawyers, and I wish you both very well. Have a great day.
Thank you, sir. Likewise.
Thank you.
Next case for Mr. Romero, page 3, number 8.
Melissa Lopez Ramos versus Rolando Ramos, cause number 2024 FLA 1640C3. Court marks Mr. Romero present in person. Ms. Ramos, step in front of the microphone, speak loudly into it and tell the court, are you Melissa Lopez Ramos?
Yes.
Welcome to court, Ms. Ramos. Court marks you present in person. The person to your left is your lawyer. Mr. Ramos, speak into the microphone and tell the court, are you Rolando Ramos?
Yes, sir.
Welcome to court, Mr. Ramos. The court marks you present in person. Mr. Ramos, do you have a lawyer?
No, sir.
Will you be going forward today without a lawyer?
Yes, sir.
Court marks you self-represented. Mr. Romero, go ahead.
Yes, Your Honor. I spoke to Mr. Ramos. We have an agreement as to the motion for enforcement, Your Honor. The agreement is that Mr. Ramos will be given 2 months to try to buy out my client from the sale of the residence. If in the event that he cannot buy out my client, then the home will be immediately placed for sale. And then Mr. Ramos has also agreed to allow a realtor to go into the house to give us a true value of the home, Your Honor. And then in terms of the other 2 items that were pending on the motion for enforcement, Mr. Ramos has complied, Your Honor.
Before I ask Mr. Ramos, Mr. Romero, I just want to make sure that the terms are clear on the record. Because if approved, then it'll should turn into concrete orders, very specific. So I guess 2 months from, first question, 2 months from today or 2 months from the time that order is signed?
2 months from today, Your Honor.
All right. And then you said to buy out with Ms. Ramos. I'll ask you one in a second. Just be patient, please. To buy out Ms. Ramos, to buy her out at a specific amount or amount to be determined by some other person?
The amount will be determined, Your Honor, based after the fact from the realtor providing us with a fair market value, Your Honor. And then we will, Mr. Ramos and I will sit down and determine the price, Your Honor.
But what if you don't agree to the price? In other words, if the order says he has 2 months to buy out and he says it's worth 10 and you say it's worth 12, it's non-specific and non-enforceable.
Well, I think the value of the home will be determined by the realtor, Your Honor, and that's the agreement by
Right.
Mr.
And-
Ramos and myself.
And that's the next part of you may lower your hands. And that's the next part of the question. Have you been able to agree with Mr. Ramos as to a specific realtor?
Yes,
Okay, what is the name of the person?
his name is Mr. Ricardo Arizola.
All right. And then you said, if for whatever reason that is unable to happen or doesn't happen for whatever reason, it'll get sold for a specific value or whatever value it can sell.
For whatever value it can sell. Yeah.
And it'll be sold by this person, Realtor Arizola?
Yes, yeah.
All right. Mr. Ramos, I'm going to ask you to raise your right hand. Do you solemnly swear or affirm that the testimony you will give in this cause will be the truth so help you God?
Yes, sir.
You may lower your hand, sir. Is your true and correct name Rolando Ramos?
Correct.
Did you hear the agreement that was told to the court by Mr. Romero?
Yes.
Is that your agreement with Ms.
No,
Ramos?
not on the 2 months from today,
What is your agreement?
because I still need to get a job.
My question is not why, but if that is your agreement. So you may have, I will grant you that there are probably some really good reasons. I don't want to know the reasons because it's
Yeah.
not going to matter. What is going to matter is what is the specific agreement? So Mr. Romero thinks it's 2 months from today. You think it's something else. What do you think your agreement is?
Boy, it can't be from today. It's impossible.
Well, but one more time, my question is, what is your agreement? He thinks it's 2 months from today. You think it's something else. What do you think your
I
agreement
said
is?
2 months from February,
What day in February?
the first day.
All right, so you think your agreement, and you can agree to 2 months from February the 1st, 2026?
Yes.
Yes, maybe, or yes, definitively?
Can I see the calendar on my phone?
Sure.
No, sorry, it can't be 2 days. It needs to be more time than that.
All right, so you tell me. I don't know your situation. You tell me what your agreement is.
I would say at least 3 months. If it's from today, we can go 3 months, if that's okay with the,
Well, I don't know. I'm about to ask. So, all right. So let's set that first issue aside. So you can agree to 3 months from today.
correct.
You heard the rest of the agreement that Mr. Romero told the court for his client, Ms. Ramos. He says, you're modifying it, and I'll ask if that's agreeable. 3 months sold by Realtor Ricardo Arizola. If not, then Realtor Arizola would place the home for sale for whatever value he can get for the home. Is that your agreement and counter offer to Ms. Ramos?
Yes.
Do you believe that this is good, right, and just?
Yes, sir.
Mr. Romero, response?
So if I'm looking at my calendar, I'm assuming if he's saying 3 months, that would put it at April 28th.
Well, that's a question to you, Mr. Ramos, because now Mr. Romero is correct. I can't just say 3 months. It has to be on a date certain so that if it doesn't happen by that date, because if we say 3 months, it could be one day, the day before, the day after. So, Mr. Romero, you believe 3 months is on what day?
April 28th, Your Honor.
3 months from today would be April 28th, 2026. Is that your understanding, Mr. Ramos?
Yes, that's correct.
All right, so knowing that Mr. Ramos can agree to the house being sold on or before April 28th to 26, is that term and all those terms agreeable, Mr. Romero?
Yes,
All right. The court has heard this agreement told to the court on the record in open court. The court hereby adopts and approves this agreement and finds that this resolves the motion for enforcement of property division. These are the orders of the court, and these orders are due to the court on or before.
February the 23rd at noon by submission.
Ms. Ramos, one other question, Mr. Ramos, and you are under oath. you've entered this agreement without without a lawyer present. Have you entered into this agreement voluntarily?
Yes, sir.
Did anybody force you to enter this agreement?
No, sir.
All right, court reaffirms its approval. These are the orders of the court, and those orders are due on or before February 23rd at noon by submission. Ms. Ramos, do you have any questions for the court? Mr. Ramos, do you have any questions?
What was that, February the 23rd?
So all of this was oral.
Mm-hmm.
On February the 23rd, that's Mr. Romero's date to put all of this in writing, and I'm going to sign off on those orders so that those orders are now in writing. It's oral, it's on the record, but you're going to need some definitive, specific, and written orders. Those are the dates that they're going to be turned in, and I'm going to sign them either on that date or the day after. Do you have any other questions, Mr. Ramos?
No, sir.
I wish both you and Ms. Ramos very well. Have a great day.
Thank you.
Thank you, Your Honor.
Any other cases for Mr. Romero?
That is all for Mr. Romero.
Have a great day.
Thank you, Your Honor.
Next case is page 5, number 13, the attorney Ruben Arce.
Veronica Contreras versus Benito Antonio Bundock, cause number 2025 FLA 1450C3. Court marks Mr. Arce present in person, Ms. Madeline Escoto present and participating by video conference. Unmute your device, please, and tell the court, are you Veronica Contreras?
Yes, Your Honor. I'm Veronica Contreras.
Welcome to court, Ms. Contreras. The court marks you present. You're participating by video conference. Benito Antonio Bundock, are you present?
Good morning, Judge. Mr. Bondoc is not present.
Understood. Mr. Arce, Mrs. Escoto, go ahead.
Yeah, we're set for a final pretrial this morning, Judge. I know that I was working on an inventory with Ms. Contreras. I still owe that to Mrs. Scotto, Judge. We should finalize that this week, and I think we're set for trial at sometime early February, Your Honor.
One of the benefits, Mrs. Scotto and Mr. Arce, about what's happened this week is that good things happen when lawyers talk, good things happen when judges talk among themselves, and it was clear to many of us that the exchange of inventories must be firmer. So let me ask you two questions, Mr. Arce. One, you're the petitioner in this case. What is your understanding as to when this inventory was due?
Your Honor, it was due on, I believe it was the last setting, Judge.
Yeah.
But I know that Mrs. Scott had filed a motion for continuance, which allowed us to work on it. Your Honor, I just need to finalize it, but we should have it done by the end of this week, Judge.
So tell the court, what, I think you just did, what specific date do you believe would be reasonable and necessary for the court to have that ordered without need for any other additional time?
Judge, we should have it done by this Friday, Your Honor. I believe that I've been confirmed with my client. It's just, she just needs to verify.
Ms. Escoto?
Judge, that is correct, Judge. I've already filed Mr. Bondoc's inventory, and I included all the sources of values in the statements attached to the same, and that was done by sending it to Mr. Arce. I don't have an objection to the deadline of January the 30th, as long as he does it by 5 p.m. And then I will send him an offer of settlement as soon as possible, Judge, right after that.
Well, let me ask you this, Mrs. Scotto, because I heard the same thing, that he can get it done by Friday. I was actually going to order it by Monday because ostensibly, I don't believe you would work on this, and I wouldn't expect any lawyer to work on this over the weekend. But if it isn't ready, I would expect the producer, in this case, Ms. Contreras, to work on it over the weekend to meet that deadline. Mr.
That's
Arce,
fine. I didn't want to file a motion to compel. I told Mr. Arce that I would just give him the courtesy of just announcing today a deadline.
Sure. Yeah, I don't think anybody's going to review this on a Saturday or Sunday, but if you need that time to work, then go ahead and work on it. So this is due to Mr. Bondock's counsel on or before Monday, February 2nd at 9 a.m. All right, and then you'll come back for your, so other question, Mrs. Scotto, when you say you filed it, did you file it with counsel into the case, into case center?
It was filed into the file, Judge, not into case center yet. But Mr. Arce received through the e-filing just on the service only the sources of values, and that included the statements for each individual.
I asked because it also became clear to the court that I should keep a much tighter handle on whether it's filed into the case, filed into case center, just exchanged, or what that process is for each individual case, but well taken on all fronts. Ms. Contreras, do you have any questions for the court?
No, I don't, Your Honor.
Keep in contact with your lawyer. It's necessary for you to exchange and tender this information to Mr. Bondock's lawyer before Monday morning. Keep in contact with him as Mr. Bondock will do the same with his lawyer, and you'll come back for your final hearing on February the 10th at 2 p.m. Ms. Contreras, do you have any questions for the court?
No, I don't, Your Honor.
Anything else on this case, Mr. Arce?
No, Your Honor.
Ms. Escoto?
Nothing further on this case, Judge.
Thank you both. Ms. Contreras, I wish you and Mr. Bondock very well. Have a great day.
Thank you.
Next case from Mr. Arce, page 9, number 26.
Vanessa Medina versus Aizar Conrado Medina Jr., cause number 2026 FLA 263. Court marks Mr. Arce present in person. Speak into the microphone, please, and tell the court, are you Vanessa Medina?
Yes.
Welcome to court. The court marks you present. Your lawyer is on your left. Aizar Conrado Medina Jr., are you present? Court finds Mr. Medina Jr. not present in court, not present by video conference, and court takes judicial notice that he was served with process January 13th, 2026. Mr. Arce, go ahead.
I'm here.
Give me 1 second. Ms. Anderson, go ahead.
Good morning, Judge. I am here present for Mr. Medina, and he was logged on. I don't know if, oh, there he is.
Unmute your device, please, and tell the court, are you Aizar Conrado Medina?
You didn't unmute.
Yes, Your Honor. I'm Aizar Conrado Medina.
Welcome to court, Mr. Medina. Court marks you present participating by video conference. So is your lawyer, Ms. Arce, excuse me, Mr. Arce, Ms. Anderson, go ahead.
Judge, I did speak to Ms. Anderson. I know that she had found an answer in this matter, Judge, and we did confer yesterday. Judge, we're just asking for some time. And I believe that we can reach a settlement agreement in this matter. As we did confer yesterday, Judge, and there's a couple of issues that just need to be ironed out, but we do feel confident that we can get that squared away.
Ms. Anderson.
Yes, Judge. We were suggesting possibly a pretrial setting to see if we can resolve this. The parties had been previously divorced, so there's a divorce decree with orders regarding visitation. So I don't believe that we need any temporary orders in this cause. I will be filing a motion to modify in the divorce, in the original divorce action, which is also in this court. And we believe that this case may end up either getting non-suited or we will be contesting the marriage in this divorce action, because the parties were divorced in 2022.
In way of background, this is a matter where we had filed a new divorce, being that the parties were together again, Judge. But if we can resolve it one way or another, Judge, we'll figure it out, which is the best way to do it.
I guess we'll take it on all fronts. I guess the only question the court has is, in that 2021 original divorce, is there a child, any child orders there for possession, access, and child support?
Yes, there is, yes. The only thing that I need to modify is the child support, because when they were divorced, they agreed to continue to cohabitate and reside together. So there was no child support amount, given that my client was paying the household expenses. Now they have separated. So now we do need to establish a child support amount, given that they no longer reside together and the children don't reside with my client anymore. So I will be filing a motion to modify that SAPSTR in the previous divorce action so that we can establish a child support amount. But the decree already establishes an extended standard visitation schedule for my client and conservatorship rules and everything else.
There's a lot to unravel there, and understandably, because people live lives, right? Things happen, things change in every person's and every family's life. So a couple of things for each lawyer to think about between now and the next setting. If Mr. Arce non-suits this case, that ends there. And then to Ms. Anderson's point, then in the underlying divorce, the 2021 case, the modification would happen there. If Mr. Arce either proceeds on this case and or Ms. Anderson counterfiles in this case, and there is a necessity to modify anything regarding the children, then those two cases should be consolidated. So a lot of possibilities, but a lot to think about. What all this means, Ms. Medina and Mr. Medina, is that it's very necessary that you keep in contact with your lawyers. You express your wishes and desires as they're best for each of you and your family. And then we'll come back for a final pretrial hearing between now and April the 2nd. Ms. Flores.
Yes, Your Honor. Final pretrial, March 5th at 9 a.m.
All right, Ms. Medina, do you have any questions for the court?
No, everything's fine.
Same question to you, Mr. Medina. Do you have any questions? Court, he sees head shaking, indicating no. Mr. Medina, Ms. Medina, I wish you both very well. Please keep in contact with your lawyers. Good luck.
I'll be in contact with Ms. Anderson, the interim judge, to iron out any small details.
I'm confident you all can work very well together. Even if you can't get to an agreement, I'm confident. Thank you, Mr. Arce. Thank you, Ms. Anderson.
Thank you, Judge.
It's good to see you. Have a great day.
Likewise.
Next case, page 6, number 15, Attorney Adriana Maddox.
This is Monica White, Brian White, cause number 2025 FLA 1592C3. Court marks Ms. Maddox present in person, Ms. Lopez Escoto present and participating by video conference. Good morning to both.
Good morning again, Judge.
Monica White, Brian White, are you present? Court finds neither person present in person or by video conference. Ms. Maddox, Mrs. Escoto, go ahead.
Judge, we entered an agreement regarding temporary orders and Mrs. Cotto will be filing that shortly if she hasn't already.
So that is correct, Judge. I had filed a fiat for the entry of the temporary orders, and so that was filed this morning. We're just asking that the clerk print it for the court and the court sign it so that the parties can have temporary orders. And then the second thing, Judge, is that even though we're set for trial on the merits, Ms. Maddox owes me her client's inventory and statements. So I'm just going to ask the court to give her some time to do so. That
correct,
we can come back to final hearing, Judge.
And it was my inventory was due on January 9th. There's some separate property tracing issues. And my client is working with the title company to get those documents. And so I'd rather give her a complete and accurate inventory than one that's missing information. And so I just need about a week to be able to complete that.
I have no objection. No objection, Judge.
I think that's a perfect response. Deadline was this date. We're working on it, and so when you say a week, I just want to put it on the record, Ms. Maddox. Give the court the date that you believe would be reasonable and necessary to produce.
So if I could have by the end of business on February the 4th.
4th?
Yes, that's 1 week.
Ms. Escoto, response.
No objection, Judge.
By agreement, the court hereby adopts and approves that agreement. Inventory of Mr. White will be due to Ms. White's counsel February 4th. By the close of business, court finds that would be 5 p.m. So ordered. Clerk is tendering the temporary orders to the court. It is well, since you're here, Ms. Maddox, I would prefer, because there's a line for you and it isn't signed, I would prefer if you're here, if you want to take a minute to review and then sign or not sign, to give you that opportunity.
I've already reviewed it, Judge. There was an issue that we had about certain language and we agreed that she was gonna sign it without my she was gonna e-file it without my signature.
Okay, so do you want the court to sign it without your
Yes, Your Honor.
signature? All right. So noted on the record.
And Your Honor, Catherine Garcia with the AG's office, if I could make a quick announcement on this case.
Yes, ma'am.
Your Honor, we did not file an intervention, but we do have an active case open. There is a prior SAPSR order that is running, a modification order from 2024. And that cause number is 2015 CVW 001741C3. At this point, I would just ask the attorneys to forward to us the signed temporary order once they receive it so we can enter that.
On this
sorry.
case,
What?
on this case, Ms. Garcia?
Are we
This
on
is
the
one-
white?
Oh,
Yes.
yeah, yeah. Oh, I didn't know that.
Miss-
Okay. Can you-
Miss,
can you
Miss
give me that
Miss
call?
Garcia, court marks you present and participating by video conference on behalf of the Attorney General's office. For the benefit of all, Miss Garcia, please repeat the cause number much slower, please.
2015 CVW 001741C3.
Well taken, so noted. Court has received, reviewed, and signed off by agreement the temporary orders. Court is tendering the original signed orders back to the clerk's office. So ostensibly, Mrs. Cotto, Ms. Maddox, you need a final hearing date, a trial on merit state?
Correct, Judge. We've agreed that if we can't resolve it, we'll go to mediation, but if we can have a date in February, that would be
February date,
Well,
Ms. Maddox?
I would prefer a March date only because February is next week.
yeah, and the only concern I have, the parties are cohabitating in the same house. And so that always brings a bit of stress. And so the faster we can get these people divorced, the better it will be.
Ms.
And
Flores, give us 2 dates, a final pretrial in February and a final hearing in March.
Final pretrial, February the 24th at 2 p.m. And final hearing would be March 31st at 2 p.m.
So what the court is going to want to hear on February 24th is if there's any issues that need to be resolved, any cohabitation, and if there isn't a final agreement, if you have agreed to a mediator, and if a mediation date has been set, in any event, we'll come back for final hearing as necessary on March 31st. Please look at that case noted by Ms. Garcia. Let me hear from the clerk, please.
Your Honor, if I may, Ms. Garcia mentioned the white case. I think she's referring to page 6, number 16. I checked the 2015, Your Honor, and it's Myra Hernandez and Michael Wesley White, Your Honor.
Yes, Your Honor.
Same surname, different case. Understood.
Oh, I'm sorry, Judge. I apologize. I heard white. Sorry.
I didn't think that this would have escaped Ms. Escoto and Ms. Maddox. All
Wait,
right.
I
that's why
apologize.
I was confused because they've been living together. So
We're very much appreciated, Ms. Garcia. Thank you, Ms. Maddox. Thank you, Mrs. Cotto. Any other cases for Ms. Maddox? All right.
Further down the line.
But nothing for me, right? Because
For Mrs. Cotto,
Yes,
not for Ms.
I'm-
Maddox. That is not
okay.
for Ms. Maddox.
Have a
Maybe
great day.
excuse Judge.
Yes.
Sure.
Next case, Your Honor.
Maddox, I thought that she had a case with me,
On,
Alyssa Saldana.
yes, page 9, number 24 from Ms. Maddox.
Oh, page 9, case 24, Carlos Eduardo Barrera Sr. versus Blanca Perales, cause number 2025 FLI 1487C3. Court marks Ms. Maddox present in person, Ms. Melissa Saldana present and participating by video conference, Ms. Catherine Garcia present by video conference. She's here on behalf of the Attorney General's office. Speak into the microphone and tell the court, are you Carlos Eduardo Barrera Sr.?
Yes, my name is Carlos Eduardo Berra.
Berra, Mr. Berra, welcome to court. The court marks you present. You're participating by video conference. Blanca Perales, are you present?
She's not present, Judge, but she's on standby and I'm present on her behalf.
So noted, well taken. Ms. Saldana, Ms. Maddox, go ahead.
Yes, Your Honor. In this case, I This stems from a divorce decree out of Georgia. My client and I filed a petition to modify the parent-child relationship after my client was served with a petition to modify filed by the OAG. Prior to the OAG filing their motion to modify, I had called and they told me that they were going to register the Georgia decree. However, I found out recently that that was not in fact done. So because it wasn't done, now I'm asking for a motion to abate so that I can register the Georgia decree and we can proceed with the modification.
Ms. Maddox?
This is the first time hearing about it. She didn't confer with me. I don't believe I have a problem with it, but, I haven't discussed that with my client.
Well, let me, so this is
But today we're set for temporary orders, and so I think we just need to not proceed on the temporary orders. And hopefully we can get this decree registered by the final TOM date.
Well,
Ms.
Your Honor,
Give me one second. Ms. Maddox has articulated the court's thoughts. So I understand you're asking for an abatement, but this is your request for temporary orders. So if you don't move on your temporary orders and you drop those or abate them yourself, nothing happens between now and March the 5th. So procedurally, what is the benefit of the request to abate, Ms. Saldana?
so that we can actually proceed with a temporary order, we need to first register the divorce decree, and then we can proceed with this case, which would include our request for a temporary order.
How do you proceed with temporary orders if a case is abated?
Well, we don't. That's why we need to abate. That's why we're requesting to abate the case so that we can then register the Georgia divorce decree and then proceed with the temporary order.
But why do you need an abatement to do any of that?
Reset? Can we reset the case? Can we reset the temporary order so that we can register the Georgia decree?
Ms. Maddox?
I don't have an objection to resetting this case, but I think we already have a final TOM date. So I think we just stick to the final trial date that's set for March. And then hopefully she can get it registered before then. And if she needs temporary orders before then, or on that date, she can submit her fiat. Instead of filing an abatement.
That sounds,
It just creates
that
work for all.
sounds procedurally sound. Tell the court how or why the court should deviate from that request, Ms. Saldana.
I can work with that as long as I can still file a fiat for a temporary order once I have this Georgia decree registered. Now, of course, if we get to March 5th, I don't know what's going to happen by that point, but I need to register this Georgia decree before we can proceed with anything on this case.
But so when you said that, like, so what is involved specifically with registering a decree?
Well, we need to get the original copy of the Georgia order. We need to make a request through the court here in Webb County. And then that way
A
we
request through the county to request a decree in Georgia?
we have to register the Georgia order in Texas.
Right. Tell the court what is involved in that process.
All I have at this point is that we get a certified copy from Georgia order with a letter of request and verified statement to the district court in the county where the child resides. So in this case, it would be the county court because it's not in the district court right now.
Yeah. All right, Mr. Berra, your case is currently scheduled for final pretrial March the 5th. I'm going to call this case on that day. Between now and then, keep in contact with your lawyer. Ms. Perales will do the same thing, and the court will hear any request that you or Ms. Perales makes to the court, if necessary, and requested in writing between now and March the 5th. Mr. Berra, do you have any questions for the court?
No, Your Honor.
I wish you well. Anything else on this case, Ms. Saldana?
No, Your Honor.
Ms. Maddox?
No, Your Honor.
Ms. Garcia?
Your Honor, I would just like to inform the court, the AG's office, we filed a suit for modification UIFSA one of the, or some of the attachments to our pleading is the Georgia order. And then there's also a notice of registration of foreign support order that was filed that's an attachment to our pleading. So it may not be necessary, but it does look like that is required to be signed by the district clerk.
So ostensibly and possibly, Ms. Garcia, the work from the AG's office may have procedurally already complied with the statutory requirement.
Possibly.
Ms. Alanya, can you follow up on that? That may have cut your work in by much.
Exactly, because I've heard something different from the OAG court. So I need to confer with Ms. Catherine Garcia, just so that we're on the same page and make sure that we're ready, that the Georgia decree is in fact registered here, or if it's not, then I need to do what I need to do.
All right. I wish all persons well. Have a great day.
Thank you.
Thank you, Judge. Maybe excuse?
Yes, have a good day.
Next case, Your Honor, page 3, number 6, with Attorney Oscar Vela.
This is Noemi Mireles versus Luis Castillo, cause number 2023 FLC 1507C3. Court marks Mr. Vela present in person. Good morning, counsel.
Good morning, Judge.
Please unmute your device and tell the court, are you Noemi Mireles?
Yes, I am.
Welcome to court, Ms. Mireles. The court martial present, you're participating by video conference. As you can see and hear from your device, your lawyer is present in court.
Okay.
Court marks Ms. Catherine Garcia present by video conference. She's here on behalf of the Attorney General's office. Luis Castillo, are you present? Court marks Mr. Castillo not present. Mr. Vela?
Judge, this case originated.
Yeah.
Are you Luis Castillo?
Yes, sir.
Welcome to court, Mr. Castillo. The court marks you present. You're participating by video conference. Mr. Castillo, I need you to find a safe and secure place to be still.
Okay, I'm here right now.
Mr. Castillo, do you have a lawyer?
No, not right now.
Are you going forward without a lawyer?
Yes, sir.
Court marks you self-represented. Mr. Vela, go ahead.
Judge, this case originated with a motion to enforce and a motion to confirm arrearage filed by the Attorney General's office. Subsequently, Mr. Castillo filed a motion to modify with a request for a TRO. We filed an original answer and we were set today for final hearing. However, I have not received any of the information that the Attorney General's office had requested Mr. Castillo to provide for the modification of child support, and I'm not sure if they're ready to proceed. I'm asking for a continuance so that we can get the documents in place before we proceed with the final hearing, Judge.
Ms. Garcia?
Your Honor, the main reason we filed this suit was because the prior order from 2024 did not include step downs, and I believe there's 5 children. And also there was an issue with the medical support language. It's a 2024 order. I don't know that we were seeking to modify the support, but I'm not opposed to a continuance if Mr. Castillo can provide us with his current pay records, pay stubs, and earnings information.
I was going to ask Mr. Vela to specify before asking Mr. Castillo how much time he requires. And then I'll ask you the same question, Ms. Garcia. Mr. Vela, what specific information are you requesting and does your client require?
The information that was listed in the Attorney General's petition asked for income tax records, 1099s, W-2s for the year of 2025. And also they asked for the paycheck stubs received prior 3 months. And they asked for policies of insurance, description of benefits, which is the standard request asked for the Attorney General's office. This petition by the Attorney General's was filed on October 24th, 2024, and it was pushed several times with Judge Mendez. So basically the income information for 2025, Judge, and the income tax for 2024 as well.
This is the information requested by your office, Ms. Garcia?
Yes, Your Honor.
Mr. Castillo, you heard,
Sorry, this is a lot of.
I understand. Find
All right, go
a
ahead.
safe and secure place to be still in court. Mr. Castillo, what the court heard from the Attorney General's office and from Ms. Mireles' lawyer is that the information requested and necessary to complete this case includes your income tax information for 2025, your 1099s, if any, from 2025, your W-2 from 2025, and your pay stub for 3 months. Do you understand this?
I understand, but I don't get paid with checks for nothing. It's cash.
So my question now is,
I have a
you-
picture of a check.
listen to my questions.
All right.
Have you filed 2025 income taxes?
No, I'm speaking with my employer right now. If like how am I gonna like do it? Like does he give 1099s or not? And he hasn't replied to me.
What is your understanding of when your employer is going to do that?
I'm not sure. I haven't asked him.
So here's the thing. I'm about to order it. And if you're in violation, there will be consequences. So I need to hear from you. How much time do you believe would be reasonable and necessary for your, I mean, if you were working in 2025, you should pay income taxes and your lawyer is obligated to provide you all of that financial information. And if he hasn't done that yet, that person or entity is probably facing some penalties at this point. So, knowing all of this, how much time do you believe you would require to get that information to the Attorney General's office?
Give it like a week or two, more or less. 2 weeks max.
The court thinks that that would be.
Are you there? No.
The court believes that that would be a good and reasonable amount of time. And this is really a deadline not only for you, but for your employer to comply with all of the requirements. You've asked for 2 weeks. I'm gonna give you a little bit more. This will be due by February 13th by 5 p.m. Should they go, Ms. Garcia, should that information be sent to your office or to Mr. Velas?
Your Honor, it can be sent to the AG's office and since it was our request.
All right. Make sure you give all of this information to the Office of the Attorney General, the AG's office, the Child Support Division. That includes all of your income tax information for 2025, which includes any 1099 W-2s and your pay stubs or whatever would reflect the amounts you're receiving from your employer for 3 months. Get that to them on or before February 13th at 5. Do you understand this, Mr. Castillo?
Yes, sir. Sure do.
Do you have any questions for the court?
Not at the moment. I thought that we were going to modify the child support side so I can start paying, but okay.
Well, the thing is, in order for the court to order you to pay any amount, the amount has to be true and correct based on your earnings, your salary, and what you make. And without that information, any amount that I order would not be correct, and it would be speculation, and I can't do that. All right. This is
Okay.
your request, Ms. Garcia. So file an order ordering all of this to be done on or before orders due.
February the 23rd at noon by submission.
So they can file that before, but I'll sign it as soon as it comes in, the order that orders Mr. Castillo to produce all of this. And then we'll come back for a final hearing on after February the 13th.
That'll be March 31st at 2 p.m.
Thoughts, questions, concerns, or objections, Mr. Vela?
Just want to advise the court and to my understanding, the Attorney General's office attached a pay history and there have been no payments since the entry of the last order, which was dated February 6, 2024. There's been zero child support. And I know they have a motion to compel, a motion for contempt and for enforcement. So I just wanted to advise Mr. Castillo if he could begin to make his payments.
This is, this information is reflected in your filing, Ms. Garcia?
Your Honor, I'm looking up the case so I can report to the court kind of the status. There have been some payments that have come through, but not since January of 2025. And I have that the current arrears balance is about 41,000. And what we have before the court is not a request for contempt. It's just it's a suit to modify and confirm the arrears, to request a judgment on the arrears. We do not have a request for contempt.
So what all this means, Mr. Castillo, and what Mr. Vela is trying to do very politely is just advise you that the AG's office is looking to take a judgment, and any non-payment of child support is subject to other legal remedies, penalties. And so he's just trying to raise that red flag that you really need to stay up to date with your payments to avoid any negative legal consequences. Do you understand this?
Yes, sir, I understand. But what about the time that we were back together? Because on January, when I stopped giving child support, we got back together and we separated on summer. So can I get credit for that?
So two things. Number one,
I was basically for writing.
Let me speak, please. Number one,
okay.
If you would like for the court to consider anything, in other words, if you need to make that request, make sure you do it in writing so that the Attorney General's office knows and they have notice, and that way nobody can object to you making that request, which is about to happen, I'm sure, even though we're not set for it. Same thing to Mr. Vela. He needs proper notice that you're going to have this as a defense, and you're going to put this in writing. And number two, without knowing anything else, let me take judicial notice of the entire case file. If what you're saying is true and it's for the period of a summer, the court can't imagine or presume that you're behind $41,000 just for one summer. So keep up with your child support obligations, sir. And we will see you and Ms. Mireles in court on March 31st at 2 p.m. Do you have any other questions for the court, Mr. Castillo?
You said 2 p.m., right?
Yes, sir.
March 31st, 2 p.m.
Yes, sir. Ms. Mireles, do you have any questions for the court?
No, I don't, sir.
Anything else on this case, Mr. Vela?
No, Judge.
Ms. Garcia?
No, Your Honor.
Thank you, Mr. Castillo. Ms. Mireles, I wish you both very well. Have a great day. Any other cases?
Thank you. Likewise.
Yes, Your Honor, the same page 3, number 7.
Alicia Karina Barzola versus Luis Arturo Arriaga, cause number 2023 FLI 681C3. Court marks Mr. Vela present in person. Ms. Leticia Garcia is present. She's participating by video conference, as is Ms. Catherine Garcia, and she's here on behalf of the Attorney General's office. Speak into the microphone and tell the court, are you Luis Arturo Arriaga?
Sí, señor.
Yes, sir.
Welcome to court, Mr. Arriaga. Court marks you present in person. The person to your right is your lawyer. Alicia Barzola, are you present? Court marks Ms. Barzola not present in person or by video conference. Ms. Garcia, Mr. Vela, go ahead.
Judge, we have this case, which is a SAPSR case, scheduled for today, but Ms. Garcia had filed a divorce case with this court as well that's scheduled for the 12th. Me and Ms. Garcia are asking the court to let us continue this case to see if we can resolve the matter in the divorce matter. And we would request a continuance of this date, Judge.
That's correct, Your Honor. We think that we can resolve all the issues arising really from the purchase of a homestead. So I think an informal between the four of us would help alleviate and resolve everything that we've got.
Sure. And you said, Ms. Travella, that there is a companion divorce case already scheduled for hearing on February the 12th?
That's correct, Judge. On case number 2025 FLA 001647C3.
So let's do this so that the court doesn't lose either one off of its radar. We'll take it on all fronts. Ms. Flores, let's schedule this case for final pretrial hearing on February the 12th with that case, and that is at,
That is at 9 a.m., Your Honor.
and then give us a final hearing after February the 12th, please.
March 5th at 9 a.m.
Thoughts, comments, questions, or objections, Ms. Garcia,
No, Your Honor, thank you.
Mr. Vela?
That's correct, Judge. That's fine.
Do you have any questions for the court, Mr. Arriaga?
No, sir.
Okay. Keep in contact with your lawyer, Ms. Barzola will do the same thing. I wish you both well. Have a good day.
Gracias. Thank you.
That is all for Mr. Vela.
Good to see you, Mr. Vela. Have a great
Likewise,
day.
Judge. Thank you. Have a good day.
Next case, page 7, number 20, with Attorney Juan Hernandez.
Arlene Caldera versus Marcos Caldera, cause number 2025 FLB 1441C3. Court marks Mr. Hernandez present in person, Ms. Lopez Escoto present and participating by video conference. Please step in front of the microphone. Speak as loud as you can into the microphone and tell the court, are you Arlene Caldera?
Yes, I am, Your Honor.
Welcome to court, Ms. Caldera. The court marks you present in person. The person to your left is your lawyer. Marcos Caldera, are you present?
He's in the well of the court, Judge,
The virtual well?
the virtual well. I see his name.
Yes. Are you Marcos Caldera?
Yes, I'm Marcos Caldera, my honor.
Welcome to court, Mr. Caldera. The court marks you present by video conference. As you can see and hear from your device, your lawyer is also present and participating by video conference. Mr. Hernandez, Mrs. Cotto, go ahead.
Judge, I know that.
I think that we have an agreement, I guess. We would like to ask the court to send us to mediation.
But if you have an agreement, why would you need to go to mediation?
So
An agreement to mediate.
yeah.
Exactly.
So I haven't been able to confer with Mr. Hernandez, Judge. I know he was in federal court this morning. Maybe if he can just call me, if you can put us on recall so that I can go over my request in both of my motions. It's a motion for mediation and then a motion to modify the temporary orders. So if we can just confer first so that we can come and tell the court what the announcement is.
Well, I mean, if we're gonna have a hearing, let's have a hearing, but if we're gonna have a mediation, then why are we gonna go and try to modify anything that the court has already?
I see what Mrs. Cotto is saying, and here's the thing, Mr. Hernandez, have you had an opportunity to meaningfully confer with Mrs. Cotto this morning?
Not this morning, Judge.
So by policy of the court, please talk to each other, and then I'll call this case.
Next case, Attorney Luis Figueroa, page 7, number 18.
Lorena Zavala versus Octavio Castillo Pozos, cause number 2025 FLB 370C3. Court marks Mr. Figueroa present in person. Ms. Leticia Garcia present and participating by video conference. They are the lawyers for the parties. Ms. Zavala, speak into the microphone and tell the court, are you Lorena Zavala?
Yeah.
Welcome to court, Ms. Zavala. The court marks you present in person. The person to your right is your lawyer. Ms. Garcia, is this Mr. Pozos, your client on your right?
Yes, Your Honor.
Welcome to court, Mr. Pozos. The court marks you present, participating from the office of your lawyer. Mr. Figueroa, Ms. Garcia, go ahead.
That we reached an agreement in this matter. The house has also been sold. The property, the funds are in the registry of the court, and we have an agreement as to all issues. I believe Ms. Garcia will read the agreement into the record.
Ms. Garcia.
Your Honor, the parties will stipulate as to the jurisdictional grounds that they have lived in the state of Texas for the past 6 months, in the county of Webb for the past 90 days. They further will stipulate that their date of marriage was November the 3rd of 2002, and thereafter separated on or about September 19th, 2024. There are no children under the age of 18 or otherwise entitled to support. And there is no one expected. She is not expecting. There is an agreement with regard to the division of the community property. Each party will take their own debts, anything in their own respective names, and or incurred from the date of separation of September of 2024. They will likewise be awarded any and all furniture, fixtures, possessions, appliances, clothing, and personal effects in their own respective possessions at this time. In the registry of the court, Your Honor, there is the sum of $115,000, $115,214.42. Each party will be entitled to 50% of those sale proceeds, being $57,607.21. Each party is responsible for their own attorney's fees and court costs. And I don't know, Mr. Figueroa, if your client is wanting the name change. I did include that in the proposed decree that I sent to you. So if that's the case, I'll just leave it in, and if not, then I can omit that later on. Your Honor, if I may ask a couple of questions of my client?
Yes, Mr. Pozos, Ms. Zavala, please raise your right hands both. Do each of you solemnly swear or affirm that the testimony you will give in this cause will be the truth, so help you God?
Yeah.
Mr.
Your Honor,
Pozos?
might the interpreter, for these just two questions, I think I do need the interpreter as well, Judge, for Mr. Castillo.
¿Usted jura que lo que va a decir en esta causa es la verdad y que lo oye Dios?
Sí. Yeah.
You may each lower your hands, having been sworn in.
Mr. Castillo, you have heard the terms and conditions that I have read into the record for the resolution of your divorce. Are you in agreement with the terms and conditions you have heard this morning?
Usted escuchó los términos y las condiciones del acuerdo que leí leí para el juzgado. ¿Usted está de acuerdo en los términos y las condiciones?
Sí.
Yes.
In your opinion, is this a just and right division of your community estate?
En su opinión, ¿esta es una división justa de su propiedad comunitaria?
Sí.
Yes.
Are you asking the judge to grant your divorce today?
¿Le está pidiendo al juez que le dé el divorcio el día de hoy?
Sí.
Yes.
Pass the witness, Your Honor.
Mr. Figueroa, questions for Mr. Castillo?
I have no questions, Your Honor.
Would you like to ask your client some questions, Mr. Figueroa?
Yes, Your Honor.
Go ahead.
Please state your name for the record, ma'am.
Lorena Elizabeth Zavala.
And you've heard the agreement that Ms. Garcia has read into the record, and is that your agreement?
Yeah.
And you're asking this court to approve that agreement?
Yeah.
And you also stipulate to the jurisdiction of the court and to the grounds of insupportability in this case?
Okay. It's true.
And you feel that this is a just and right division of your property, community property assets?
Yeah.
And you're not asking for a name change, you've always used Zavala, correct?
Yes, always.
And you're requesting a divorce?
Yes, always.
That's all I have.
Any questions for Ms. Zavala, Ms. Garcia?
None, Your Honor.
Just one question for you, Ms. Zavala. Is there any reasonable expectation of reconciliation?
No.
Anything else on this case, Mr. Figueroa?
Yes, Your Honor, we'll submit also an order for the court to instruct the district clerk to release the funds, half and half to Ms. Garcia and half to myself.
Ms. Garcia?
That's correct, Your Honor.
All right, well taken. Ms. Zavala, Mr. Castillo, in your case, cause number 2025 FLB 370C3. The court at this time finds that it has jurisdiction over this case, meaning this is the proper court forum and venue to consider your divorce. The court finds that you entered into marriage on the 3rd day of November 2002, but you stopped living together as husband and wife on the 19th day of September 2024. The court finds that there are no children under the age of 18 of the marriage and none are expected. The court finds that you have an agreement regarding the division of your property. The funds in the registry of the court that are your The proceeds of the sale of your home will be divided 50-50. The debt in each of your names, you will be responsible for that, each their own debt. Similar, any belongings in your possession are hereby awarded to you, Ms. Zavala, and any belongings in your possession are hereby awarded to you, Mr. Castillo. Each of you is responsible for your own fees, including court costs and filing fees and attorney's fees. And the court finds that this is all a just and right division. At this time, Ms. Zavala and Mr. Castillo, the court finds that there is no reasonable expectation of reconciliation, and the court hereby renders and pronounces you divorced. These are all the orders of the court, and those orders are due to the court on or before
February the 23rd at noon by submission.
That concludes your case, Ms. Zavala. Do you have any questions for the court?
No, that's fine.
Do you have any questions for the court, Mr. Castillo?
¿Tiene alguna pregunta para el juzgado, señor Castillo?
No.
No.
Ms. Zavala, Mr. Castillo, I wish you both very well. Good luck.
Thank you, Judge.
Yes, ma'am. Thank you. Any other cases for Mr. Figueroa?
That is all for Mr. Figueroa. Ms. Garcia further down the line.
Good to see you, Mr. Figueroa.
Thank you, Your Honor. I was in federal court, so that's all.
You're good on time. Thank you, sir.
Thank you. My BC.
Yes, sir.
Thank you, Judge.
Next case online, Your Honor. Attorney Mrs. Madeline Escoto, page 1, number 1.
Maynardo Montemayor versus Maria Montemayor, cause number 2020 FLA 1058C3. Court marks Mrs. Scotto present by video conference, Ms. Elisamar Soto present also by video conference. Mr. Del Barrio, Guillermo Del Barrio, are you present?
Present, Your Honor.
Thank you, Mr. Del Barrio. Court marks you present by video conference, as well as is Ms. Catherine Garcia, who's here on behalf of the Attorney General's office. Maynardo Montemayor, Maria Montemayor, any party present? Court
I don't
finds-
believe my client's present, Your Honor.
Court finds no parties present. Counsel, go ahead.
Judge, we're pleased to announce that with the assistance of Ms. Soto and her recommendations yesterday, we have filed with the court a Rule 11 agreement with regards to the conservatorship, possession and access, the loving and caring order, issues that were lingering from the divorce as well are included in that Rule 11. It has been signed by Mr. Del Barrio, Ms. Soto, and I, and we're asking the court to sign the same, and that will conclude this case in its entirety.
Mr. Del Barrio,
That's correct, Your Honor.
Ms. Soto,
That's correct, Your Honor, and nothing further on my end.
Ms. Garcia.
Your Honor, the AG's office, we did have a pleading on file. I've not seen the Rule 11 agreement. So I can't say that we're in agreement with it, but if that could be provided to us and if the proposed final order could be circulated to the AG's office before filing as well.
We didn't touch, Ms. Garcia, just so that you know, child support. I don't know if that's was part of the your intervention.
We so we've had a suit to modify and confirm arrears pending since 2023, and then both parties filed their own pleading. So and there are no arrears at this time, so there's no need to take a judgment. So I suppose that if the prior order, child support and medical support terms will stay in effect, and I suppose if your proposed new order can say that way we have a clear understanding that those terms will remain the same.
We'll include that, Judge, when we circulate the final order for Ms. Garcia's signature.
And that would be fine.
So let's do this, because I do see that suit March 29th, 2023. So let's do this. The court, without further information, hereby adopts and approves that Rule 11 agreement, tendering that signed original to the clerk's office. Ms. Flores, let's not enter this date, but just tell the court, what is the next order's due date?
February the 23rd.
Yes. Okay. Orders due February the 23rd at
noon by submission.
So let's do this. Ms. Garcia, Mrs. Cotto, and Mr. Del Barrio will circulate those proposed orders to your office before February 23rd. If you or your office have an objection, just file them on or before February 23rd. If there's no objection, the court will presume that there is no objection by the Attorney General's office, and I will sign them when they come in. If there is, we'll set those objections. Ms. Garcia, the court has been apprised by the clerk court and coordinator that your office did in fact receive the Rule 11 agreement. It was sent to your office. Well, see, that's the thing. It was sent to your office this morning at 8:42. So you should have it. You have, I take notice that isn't enough time for you to receive, review, consider, but the AG's office was served with that Rule 11.
Thank you, and I will look for that. Thank you.
Yes. All right. Orders due February 23rd by submission. Anything else on this case, Mr. Del Barrio?
No, Your Honor, not from us.
Just a
Mrs.
thank
Soto?
you to, just a thank you to Ms. Soto, Judge, for helping us.
Yes,
with-
very much so.
You've
Thank you.
gotten the parties to the finish line and saved the court some time.
Yes.
Much appreciation to you by all.
Thank you, Judge.
Anything else on this case, Ms. Garcia?
No, Your Honor, not from the AG.
All right. Any other cases for,
Mrs. Cotto is next, Ms. Soto and Mr. Del Barrio further down the line.
thank you.
Next case from Mrs. Cotto, page 4, number 9.
Tomas Castillo versus Belinda Husso, cause number 2025 FLA 799C3. Court marks Mrs. Cotto present participating by video conference, Mr. Juan Garcia present participating by video conference. They are the lawyers for the parties. Ms. Leticia Garcia is present by video conference. She's the court's appointed guardian ad litem. Tomas Castillo, Belinda Husso, if you're present, please step forward. Belinda Husso, are you present?
She's not present, Judge.
So noted. Speak into the microphone and tell the court, are you Tomas Castillo?
Yes, sir.
Welcome to court. Mr. Castillo, court marks you present in person. As you can see from this screen, your lawyer is present and participating by video conference. Ms. Escoto, Mr. Garcia, go ahead.
So Judge, on September 15th, the parties were participated in an informal settlement conference with Judge Leticia Martinez. Thereafter, she pronounced and rendered and put on the record the agreement. We were waiting for additional information as to one issue as to child support. The court then thereafter gave us her ruling. I prepared the decree. I sent it to Mr. Garcia and Ms. Garcia. Thereafter, Mr. Garcia asked to have the recording read back as to one particular issue. That recording was read back, and the decree was submitted again to council with minor changes, and Ms. Garcia and Ms. Hasso and I have signed it. I have e-filed it with the court. I'm asking that the court sign the same today. This case has been lingering since September, and the parties deserve some finality.
Mr. Garcia.
Your as to my client, Mr. Castillo, I don't think it's not so much an objection, Your Honor. It's more of a concern that he has on page 25 with the morality clause. The way it's written, he just feels that the morality clause might not end within the 4 months, because the agreement was that it would end in the 4 months. Or if the counselor recommends that the parties, I guess, undo the morality clause, they could do it sooner. And I think that's the way it's written. But my client, Mr. Castillo, believes that because it says or until a counselor recommends that the minor children should be introduced to the person he's currently living with, he believes that the respondent could tell him, no, well, the counselor hasn't recommended and it's been more than 4 months.
Okay, so let me take this, because it sounds like it's only one issue. Mr. Garcia, first question, what page and paragraph number is the proposed morality clause on?
Page 25, Your Honor.
Page 25, top of the page, clause A reads, morality clause, both parties are prohibited from introducing the minor children to any person he or she is having an intimidating relationship with, living or remaining in the same residence at any time while in possession of the minor children for 4 months from the signing of the final decree, or until the counselor recommends to the parties that the minor children should be introduced to name of person. I guess it's public record. The minor children should not have any contact with this person for 4 months from the signing or until recommended, otherwise by the counselor. In essence, that's what it says.
So the bolded is my clarification to them that it was not an and, that it was not the 4 months and the council recommended, it was an or. So in effect, if they participate in counseling, which is part of the next page of this decree, that the child would go to counseling, that the child and mom and dad would participate and follow the recommendations and pay for the cost of the counseling 50-50, then the child technically could be able to, or both children could be able to be around this person. So I've clarified it as much as I can pursuant to what was read in the record, that he doesn't understand it. I can't tell you why he doesn't understand it. It's plain English.
Right. So let me see if I can figure this out. A couple of factual questions should not be any difference as to these set of facts. Mr. Garcia, Mrs. Cotto, how many children before the court?
2, Judge.
Ages?
There is a 1-year-old. She should be 1 by now, and Zoe is. Bear with me, Judge.
Mr. Garcia?
I think he's really.
8 years old, turns 9 this summer. All right.
Yes, 8, Judge.
1 and 8. Mr. Garcia, now that the court has heard all of this, the specific objection or the concern, you said it's not an objection, it's a concern. If it's a concern, I'm just going to sign off. If you raise an objection, I'll entertain it. So if you have an objection, is it that it's too short, too long, or not specific, or something else? What is it?
I think for my client, it's that it's not specific enough because he believes that since it says or until the counselor recommends, he believes that the respondent might say, well, the counselor hasn't recommended, so even if it's been more than 4 months, you still can't have you still have to have the morality clause.
Now, Mrs. Cotto, and now I can see how that isn't specific, and it may cause an enforcement issue in the future. However, Mrs. Cotto, I believe, based on what she said, is going to respond that that was what was read into the record, and you take what's there and you put it in black and white. So tell the court, Mr. Garcia, was that the agreement that was announced to the court, or was it something else?
I didn't go over that part on the recording, Your Honor. So I don't remember that part was exactly what was said word for word. There was counseling sessions that were recommended, and that was basically the gist of it, Your Honor. But that specific words, I don't know if that what was said.
Yeah, and so this has been the problem in this case, Judge, right? That they don't remember things being said. We go back and ask Judge Martinez's staff to read back what was read into the record. And of course, the morality clause is there. It's 4 months from the signing of the divorce decree. There was also said into the record, because that's what my notes say, and I was correct the first time, or until a counselor recommends that they can go with this person or have contact with this person by way of the recommendation of the counselor. I guess so we all understand, Judge. My client is going to abide by this order. And once the 4 months are over and the counseling has started, he can have this person around her. I think the problem is the 4 months start counting from the time the divorce decree is signed. And so if we sign it today, the clock starts ticking. I think the problem is that and I know that the court did not hear the contested hearing on this case, but the court heard that Mr. Castillo injected this person into the marriage when my client was still pregnant with the smaller one, this person's children goes to the same school as the 8-year-old. Both of these two people are educators, and the person that his paramour is an educator. And so there were rumors going around in court, at their places of employment, that he may not have been the father of Zadie, who was the newborn. We had to get a DNA test done so that my client could have something to if people said that it wasn't his child, that was in writing. And so Judge Martinez heard all of this and heard also things that Zoe had heard in her classroom. And so to protect the children, that morality clause was agreed to 4 months from the signing of the decree or until the counselor recommends so. If he and Miss Hassel enroll the children, at least Zoe, in the counseling tomorrow, and the counselor says in a month she can have contact, then that's what's going to happen. But the more we delay this, the more the parties don't have any finality.
Mrs. Cotto, Mr. Garcia, the court hereby adopts and approves your agreement in full. And I believe it was told to court that everything has been pronounced and rendered. The only issue pending for the court, or the only semblance of an objection that the court has heard, is this morality clause. Let me unravel that for you and get you to finality right now. And I guess Ms. Leticia Garcia, feel free to chime in at any, and I'll ask you at the end for your thoughts. You are the court's appointed guardian ad litem. So normally, folks, morality clauses are overnight visits, and I have, I guess, just by the volume of cases court hears on family law matters, I could kind of gauge where this could be going if you have a 1-year-old and an 8-year-old. So if your agreement is that there is some amount of time, ostensibly that it is in the best interest of these children to keep some distance until first introducing, then the only question for the court then is how much time, one, is in the best interest of both of these childs, and two, can you agree to? So let me start one by one. And this is your objection, Mr. Garcia. What amount of time do you believe would be in these children's best interest?
We had, during the mediation, we agreed to the 4 months, Your Honor. He doesn't have objections to that. And he didn't have an objection to it starting after the decree is signed, because that's what was agreed to, Your Honor.
So you believe 4 months to be in both of these children's best interest, and this is your proposal. I had a follow-up question. I don't want to lose it.
Yes, Your Honor. He didn't have a problem with that. It was just the part that follows after that, or until. The way he understands it is that since it's an or, she could possibly come back and say, well, the counselor hasn't looked
my
into it.
follow-up, I remember, Mr. Garcia, my follow-up question is, nobody's under oath, so it's just attorney argument until somebody gets put under oath and it's evidence and testimony. Ms. Escoto just recited to the court some of the background facts. Do you agree with the factual basis of any of those background facts, that the difficult nature of the facts and the workplace environment and the school and all these things, does that sound right?
Yes, Your Honor.
All right. Ms. Escoto, moving on to you, the proposal by Mr. Garcia is that it is in these children's best interest and agreed to for the 4 months. Your thoughts and response?
That's what was pronounced and rendered, Judge, or until the counselor recommended sooner. But again, we go back to, we need a decree so that the order can be followed by the parties. They can enroll her in a counselor so that the counselor can start with the sessions. But all this was pronounced and rendered. So and my client's not here because this is just set for entry, Judge. And I'm asking that the court sign it the way it was submitted. And Ms. Garcia also signed off on it, Judge, because it was a true and accurate reflection of what was agreed to.
All right, Ms. Garcia, your thoughts, comments, objections, and response, if any.
Your Honor, the facts and circumstances as read into the record or recited by Mrs. Cotto this morning are correct based on my dealings with Zoe, with father and with mother. What I was not particularly involved in was the this morality clause as it came after the fact that all of my terms were taken up and set forth in the final pleading. I do agree that a 4-month period is reasonable. I do agree that it's necessary, especially for Zoe. She was having some troubles getting past the fact that, you know, perhaps father was maybe paying more attention to, you know, the other children, less than herself and her sister. And I think that that is necessary that the counselor that they begin speaking with delve into. I think the issue of the word or might not be such an issue or should not be for father, given that the counselor can come within the 4-month period if she agrees that the children, that Zoe particularly is okay and fine before the expiration of the 4 months. So it's a benefit to father, in my opinion, if it's written that way, and it seems like it is the way Mrs. Cotto has stated into the record. But you know, even though we don't use these types of clauses very frequently, in this particular case, because of the way it led up to the actual separation and issues coming up thereafter, it's necessary that Zoe have a little period of time to assimilate a little bit better.
The court has heard the thoughts, comments, response, and recommendation by the guardian ad litem. Any response or objection there to Mr. Garcia?
No, Your Honor.
Mrs. Cotto?
No, Judge.
All right, so this is what the court's going to do, and I'm going to deviate from your agreement in the best interest of, let's say, of the children, but it sounds like it's the older child that the court would be really doing this for. One more factual question before I give you a definitive date. Mr. Garcia, what school district does the older child attend?
I think it's UASD, Your Honor.
Correct, Mrs. Cotto? Mrs. Cotto, I think you're frozen. Ms. Garcia, do you know if the children attend UISD?
Yes, Judge, they do. Oops, it's gone.
Court sees that Mrs. Cotto has dropped off the video conference and is no longer in the virtual well. I have a decision. I just need to put it on the record.
She says she was kicked out, Judge.
That was her internet provider, not ours, because we're all here. I guess let me give her a few minutes to log in, and I will make a pronouncement, a rendering. I'll write it into the order as soon as she logs in. Mr. Castillo, please stand by. Stand by.
The rest of our cases were heard, Your Honor. Next attorney would be Elisa Marsoto. Page 4, number 10.
Irma Ramirez versus Ismael Ramirez Jr., cause number 2025 FLA 929C3. Court marks, well, can't call that one.
Yes, But I was gonna mention, it's with Ms. Garcia, Mrs. Cotto, Your Honor. We did file an agreed motion for continuance, but I'm not sure if Mrs. Escoto wanted to put something on the record about that.
Yeah, I presume that she's gonna try to log in shortly, so step by, please.
I will.
Attorney Rudy Santos, page 2. Number 4.
Number 3,
Yes, Your Honor.
Javier Oscar Sanchez Jr. versus Minerva Perez Torres Sanchez, cause number 2023 FLA 1706C3. Court marks Mr. Santos, present participating by video conference. Good morning, Mr. Santos.
Morning, Your Honor.
Javier Sanchez, Minerva Sanchez, are you present? Court
Yes, Your
mark.
Honor.
Are you Javier Sanchez?
Yes, I am, Your Honor.
Mr. Sanchez, I'm going to ask that you start your video, please. Once more, are you Javier Sanchez?
Yes, I am, Your Honor.
Welcome to court. The court marks you present and participating by video conference. As you can see and hear from your device, your lawyer is also present and participating by video conference. Minerva Perez Torres Sanchez, are you present? Court marks Ms. Sanchez not present in person, not present by video conference, and court takes judicial notice that she was served with process November 1st, 2025. Mr. Santos, go ahead.
Your Honor, in this matter, we're seeking a modification proceeding. We're set for trial on the merits today. We're asking that the party's final decree of divorce, naming the parties as joint managing conservators, be modified so that Mr. Sanchez be appointed sole managing conservator of his 8-year-old daughter, Grace.
So it sounds like if respondent Sanchez was served with process, hasn't appeared. Let me just ask the clerk's office, has respondent Sanchez filed any answer, response, pleading, motion, objection, or anything at all?
No, Your Honor.
All right, so this ostensibly Mr. Santos is a prove up. Are you ready to proceed?
Your Honor, I am, Your Honor. And at this time, I would ask that the court please admit exhibits A, B, and C to the original pleading.
Presume you have to do that by evidence and testimony, unless there some sort of record. So let's begin this process. Mr. Sanchez, would you raise your right hand, please? Do you solemnly swear or you solemnly swear or affirm that the testimony you will give in this cause will be the truth, so help you God?
I do, Your Honor.
You may lower your hand, Mr. Sanchez. You're under oath. Mr. Santos, go ahead.
Mr. Sanchez, can you please state your full name for the record?
Javier Oscar Sanchez Jr.
And who is Grace Marie Sanchez?
She's my daughter.
And how old is she?
She just turned 8 on January 16th.
Where does she currently reside?
She has been staying with me and my fiance.
For how long, sir?
Since August 15th of 2025.
And you are asking for a modification in this proceeding, correct?
Yes.
Can you explain to the court why it is that you believe a modification is appropriate and necessary in this case?
It's going to be for the safety of my child. I'm trying to give her, everything that she's supposed to have. And, she's well taken care of.
What about with regards to?
I just want her future. I'm sorry, go ahead.
I'm sorry, Mr. Sanchez, I didn't mean to cut you off. With regard to the child's mother, Minerva Sanchez, do you have any concerns with her and her ability to perform her parental responsibilities with respect to Grace?
I do. She has shown us within, in the past, she's not, for most of us, she's not a fit mother. For one thing, it was, her drug addictions, the people that she has contact with in Mexico and people from here. She has, dated several guys and brings guys that we don't know who they are around my child. She will come give us my daughter on the weekend when I have her and won't show up the next day for her on a Monday, or she'll call Tuesday and say, I won't be back till the evening. I have to also look for a different route on how to get her to school and who's going to pick her up. And it's just, it's been a very inactive, hard way of taking care of her with a mother like that.
And these are all changes that happened after your divorce from Ms. Sanchez, correct?
Yes.
And in fact, my understanding is that Ms. Sanchez has lived with at least 5 different men during this time.
From the time that we have separated, there's been about different guys that I have known of, that have come to like live there, and they leave, and then she'll get another guy and leave.
And is
That's
Grace
about it.
exposed to this?
Yes.
And when you're talking about these men that she dates, and that, you know, them being from Mexico, it's not necessarily you're concerned that they're from Mexico, it's what they do for a living or who their affiliates are. Can you tell the court about that?
Yes, well, some of them have been affiliated, and you know, she chooses to find somebody with money to make a living since she does not work.
Does she brag about having connections to the cartels?
Yes, she has.
Has she in fact attempted to intimidate witnesses in connection with this case, including Miss Anna Chick?
Yes, she has.
Who is Anna Chick?
That is her brother's girlfriend.
And what has happened with regard to Miss Chick and Miss Sanchez that you know of?
Well, Miss Chick has been basically, she's been threatened by Minerva about any of the information she's brought forward to me about things, and they have said that, you know, they were trying to put a plan together on how to have her picked up in Mexico. So it's pushed Anna to not really want to talk about things anymore because of that.
Is Miss Sanchez a dangerous person?
Yes, she is.
Isn't she in fact also potentially facing felony charges for illegally entering this country at least 4 times?
Yes, she's been caught 2 times before I knew her, and then she got caught 2 times recently in the last 6 months. The first time she got caught, she was incarcerated for a week, and she got sent back to Mexico, crossed back within 2 weeks, came back again to the US, and she was caught by ICE again. And she did 3 months in the detention center for I guess it was a GO or something, and she got sent back to Mexico again, where she's at right now.
Has she threatened to in fact take Grace to Mexico?
Yes, she has.
Are you concerned about that happening?
Very much.
Are you asking that the court make you sole managing conservator and limit any kind of visitation that Miss Sanchez is allowed?
I'm sorry, I don't fully understand that.
Are you asking that the court name you sole managing conservator?
Yes.
And are you asking that the court impose reasonable limitations on access and possession if in fact the court grants Ms. Sanchez any possession to Grace?
Yes.
And with respect to you as a father, Mr. Sanchez, can you provide for Grace and what she needs?
Of course. Yes, I can.
With regard to her home, what kind of home do you have?
I have a 4-room condo.
And how long have you been there, sir?
3 years. I was in the apartments, and we got the bigger side about 1.5 years, almost 2 years ago.
Are you currently in a long-term relationship?
Yes.
And do you have an intention to eventually get married?
Yes.
Has Grace already been introduced to your spouse or your soon-to-be spouse?
Yes. Mhm.
And how is that relationship?
It's going great. The improvement on my daughter has come up so far. You know, we're very proud of her. You know, she looks like she's full of life now because she's has people to talk to and play with.
What about with regard to your ability to provide for her financial needs? Do you have employment, sir?
Yes, I do.
Where are you employed?
I run hot shots over the road as a contractor, so I make my schedules.
Do you anticipate that you're going to be able to provide for all of Grace's financial needs in the future?
Of course. Yes, I do.
Have you ever had any issues in regard to providing for Grace's financial needs?
I have not.
Do you also have familial support in helping you raise Grace?
Yes, I have my fiance and my mother that's a retired teacher. They have been helping her substantially with school to bring her back to the level where she should have been at since she was living with Minerva.
And with regard to her performance in school, how is she performing in school right now, sir?
She's doing great. She's brought her grades since when she was in kinder and first. She didn't know what a D and an E was, and now she's brought all her grades up to A's and B's. She has received Student of the Month twice already this year, and she has not missed one day or gotten late one day to school.
And do you believe that it's absolutely necessary that the court modify this order to protect Grace from Minerva Sanchez?
I do.
And are you asking the court to grant that relief?
I am.
I have nothing further from Mr. Sanchez, Your Honor.
I guess the only question the court has, I guess the only first question, preliminary question that the court has in order to pronounce and render and make a decision, Mr. Santos, is that what the court heard by testimony and request is that Ms. Sanchez have reasonable access and possession under the terms of the request and the propounded evidence and testimony. What would that access and possession look like in this situation?
Your Honor, we would ask that it be strictly limited to electronic access, potentially FaceTime and telephone calls. My understanding is that the child is in no way missing the mother. I've asked whether or not
Say
counseling
that the child is what?
is not in any way asking about her mother. We suggested and talked about counseling for the child, but the child's doing very well emotionally. She does not ask about mom at all. So if anything, maybe electronic access. My understanding is that Mr. Sanchez is allowing that right now. Just strictly telephone calls.
When you say Mr. Sanchez is allowing access, so is there communication between child and mother?
Your Honor, very limited. I think there's been a few telephone calls.
Is that the case, Mr. Sanchez?
Yes, Your Honor. Last week she texted me, and she'll text me from different numbers at times, and she'll just say, "Can I talk to my daughter?" And I will tell her to give my mother a call, and we'll put her on FaceTime so that they can talk.
So in addition to the telephonic communication that your lawyer has told the court, there's also been actual video conferencing at some point?
Yes, I will allow a FaceTime. That's what the mother asked, and I allowed it.
And how
I didn't want to take that away.
How are those sessions, that communication, is that going well?
It has. My daughter, since I've had her, she does not ask about her mother. She
I know, but don't go beyond what I'm asking.
Okay,
So the
I'm
question
sorry.
is, I just need to know if the video conferencing is going well, not going well, or it's
Yes.
going good enough.
Yes, it has.
All right. Anything else on this case, Mr. Santos?
Nothing further, Your Honor. I would ask the court please take judicial notice of the affidavits filed with the original petition. I believe they're marked exhibits A, B, and C.
Right, anything else?
Additionally, Your Honor, we would ask, I know that there's no evidence, but we would ask the court impose child support on the respondent. And since there's no information regarding her income, we would ask that it be imposed in a manner consistent with the minimum wage standards.
I think Ms. Catherine Garcia, if you are present still, would you mind refreshing the court's memory as to what child support is at minimum wage?
Your Honor, excuse me, it's typically around $222. But then if there's a medical support, cash medical, it adjusts that too. It'll adjust the child support amount. So it depends on the health insurance for the child.
Mr. Santos, I'm going to ask you, Mr. Sanchez, does your daughter have health insurance?
Oh, okay.
Do you know the answer, Mr. Santos?
I do not, Your Honor.
Okay,
Once more, Mr. Sanchez, is your daughter covered by health insurance?
yeah, yes, Your Honor.
Is it public or private health insurance?
It is it's a private insurance. It's with Amber Healthcare.
How much do you pay in health insurance?
I'm paying $100 a month right now for dental, vision, and for medical.
Is that $100 payment you, her, and someone else, or just her? Your daughter.
It is me. It is me and my daughter.
Ms. Garcia?
So I would put a $50 deduction. And let me calculate that real quick, Your Honor.
I appreciate that.
And does the mother have any other minor children that she supports?
Mr. Sanchez?
She has a son, but he is already over 18. She does not support it.
So I have that child support would be $222. And also, if the order would read that dad is ordered to carry medical insurance through his employment, and mom could do a $50 reimbursement to him for the insurance for the child.
Any objection to the court making that order, Mr. Santos?
Not at all, Your Honor.
All right. I very much appreciate you, Ms. Garcia. Your thoughts, comments, observations, and calculations. Thank you.
I'm glad to help.
Mr. Sanchez, in this case, the case involving your 8-year-old daughter, cause number 2023 FLA 1706C3, the court finds that it has jurisdiction over this matter, and actually this is a petition to modify, so it has continuing exclusive jurisdiction over this matter. The court takes judicial notice of the entire case file, including exhibits filed into the case, but the court does this based on your testimony. The court hereby adopts and approves your agreement, names you sole managing conservator over your daughter. You have the right, duty, responsibility, and obligations to care for her, but and I guess you're just the joint managing conservator, which means that Ms. Sanchez has those same rights and duties if and when your daughter is in her possession. But the court gives you the exclusive right to determine her residence. The court is going to approve your request and order that video conferencing communication. I'm going to order Tuesdays, Thursdays, Saturdays, and Sundays during the week at 7 p.m. and during the weekends at 1 p.m. unless agreed to otherwise. Child support is hereby ordered at $222 per month beginning February 1st, 2026, with a medical reimbursement to you for health insurance at $50 per month. The court commends you, Mr. Sanchez, on your daughter's educational success. The court would presume that that can and will continue, and your daughter will continue to grow and thrive educationally. The court orders all of this in the best interest of your daughter. But I make one observation, that these are final permanent orders until further orders from the court. And I note that as an observation for this purpose, that people are always changing, and your daughter's not going to be 8 forever, but she will get older and then turn 18. If there's a necessity for the court to make any modifications, you can make that request, or your child's mother can make that request. The only observation I would note is that at some point, if it becomes necessary, because the policy of the state of Texas is that children have close and continuing relationships with their parents, that at some point it may be necessary to order visitation at some point. And your testimony here, and this is the observation I'm making, that the observation here is that this person was deported twice before you had a child with her, and that somehow that deportation after the birth now prevents visitation with the child's mother. I'm granting this in your daughter's best interest, knowing that that's subject to change if any other evidence and testimony is presented to the court, and it's in your daughter's best interest. But just know that if that's the case, those are situations that you put yourself in when those things happen. These are the orders of the court, and the orders are due honor before.
February the 23rd at noon by submission.
And that will include the child support and reimbursement to Mr. Sanchez. Mr. Santos, please put those into the final orders. Mr. Sanchez, do you have any questions for the court?
I don't, Your Honor.
Mr. Santos, anything else on this case?
Nothing on this matter, Your Honor.
Mr. Sanchez, I wish you very well. I wish you well, but more importantly, I wish your 8-year-old daughter all the best. Good luck to all.
Thank you, Your Honor. Appreciate that.
Calling Mrs. Cotto's cases, Your Honor.
Yes, please.
Page 4, number 10.
Is this the case that I was about to pronounce and render?
That would be page 4, number 9.
Tomas Castillo, Belinda Hasso, cause number 2025 FLA 799C3. Court marks Mrs. Cotto present by video conference. Mr. Garcia present by video conference. Ms. Leticia Garcia present by video conference. Ms. Leticia Garcia is the guardian ad litem. Mr. Tomas Castillo is present in person before the court. Ms. Belinda Hasso was not present. Mrs. Cotto, when last we left off,
I apologize, Judge. I have no idea what happened with the server.
you're here now. That's all that matters. The court was about to adopt and approve the agreement by the parties. Mr. Garcia raised, the court has crystallized into an objection. Page 25, Clause A, the morality clause. The court heard some factual background from Ms. Garcia, Mr. Garcia, and Mrs. Cotto. The last piece of information that I just needed confirmation on before pronouncing and rendering and making modifications in the best interest of both children, but more particularly the older child, Ms. Escoto, was that the older child attends United Independent School District.
You're asking me, Judge?
To confirm, yes.
Yes, I believe she is. Hold on, please. I want to say she does, Judge, at the same campus as my client, but I don't know for sure. Ms. Garcia,
I asked just to give a date certain, but it's not going to move the court's decision by more than a day or two. I just need confirmation. Ms. Garcia, I know I asked Mr. Garcia. Do you know Ms. Garcia?
Your Honor, I'm pretty sure, but I think Father is standing right there, and I got the answer, Judge.
Mr. Castillo, what school district does your oldest child attend?
Laredo ISD.
Laredo ISD. That is going to change the court's. By 3 days, it'll change my decision. All right. Any factual dispute with that, Mrs. Cotto?
Judge, I'm just, if he says it's LISD, I have no reason to believe that he would lie to the court, so.
All right, I'll presume it is. So, okay, so in this case, the court finds that it has jurisdiction over this matter. The court sees that there is a mediated settlement agreement. The court hereby adopts and approves the agreement in full, finds that it is a just and right division with regard to any property division, and the court finds that the terms of the agreement related to the children is in fact in their best interest, save and except for one thing, and that is the morality clause. Here's the court's decision, and I do this in the best interest. It isn't clear what the mediated settlement is since there's this objection. So I'm going to unilaterally make a decision based on the factual representations of and undisputed representations of the parties. And I do this in the children's best interest, but more specifically the older child. If this child attends this school and that child school was subject to some emotional concerns regarding any other adults in that child's school, then it would seem to the court, number one, that this court shouldn't enter an order that is controlled by some other person, because that date is not specific. The counselor could say tomorrow is good or a year is good, and nobody could really enforce it unless you come back with that thing that isn't really a document attached to this orders, these final orders. However, knowing that the child's school is subject to this emotional concern, then it seems to the court that what should happen in any event is that this school year should end peaceably, separate and apart from any emotional disturbance. Next year should commence, 1 month should elapse, and that gives the parties sufficient time to see if that continues to be a concern factually, number two, at school, and number three, if the counselor has any difference of opinion at that point. So, all that to say, the court orders that this quote unquote morality clause be in force until September 8th, 2026. Knowing that this is the court's ruling, Mr. Garcia, any objection?
None for me. I don't know if my client has any objection, Your Honor.
I'll hear from him in a minute. Mrs. Cotto, any objection to this?
No, Judge.
Ms. Garcia, thoughts, comments, concerns, or objections?
None, Your Honor.
You're before the court. Speak loudly into the microphone and tell the court if you have any questions or objections.
Just a question.
Yes, sir.
Is this based on them being in this, because she hasn't been in the same school since the year started. She moved schools in the last school year.
Who is she?
Zoe, my daughter. I know the concern was that they were in the same school. That was a year ago. She was in UISD when it happened, but now she's started this school year, this whole school year, she's been in Laredo ISD. So she's been since August 25, she's been in a different school. Like I was trying to make, I guess clear what you were saying.
That's why nobody knew the answer but you, because at some point,
yes.
Give me 1 second. Let me ask a question, then you can answer. At some point, your child was enrolled in one school district, and at some other point, that child moved into another school district.
Yes, sir.
Knowing all of that, the same ruling, because just like the facts change here and none of the legal professionals knew, same thing could happen again. There could be a change in school without anyone really finding out, none of the lawyers involved, and you're going to get the same result. So I hold to the court's decision knowing that information. I'm going to write this in. Before I do, Mr. Castillo, tell the court if you have any other thoughts, comments, or objections.
No, I just want to, I guess, clarification. So I would, instead of being 4 months, it's going to be all the way up to September now.
September the 8th. So your lawyer's objection is well taken, and part of the objection is that it's not specific. So it's either it's 4 months or until some other person makes an evaluation and gives you some other date. Well, that date could be soon, it could be more, it could be less. You're gonna have to file something, hire a lawyer, come back, prove that, whether that is true, and number one, and number two, whether that's even in your child's best interest. That's a lot of uncertainty. I'm giving you a definitive date, that you can work towards. Now, between now and then, should something else happen, you can always come back and tell the court that that date is too short or too long. You have any other questions?
I guess my only concern is since I would have her the whole summer, I can't take her where I'm currently living because I live with my new partner. I can't take her there. So then how would I manage getting a hotel for the whole month?
These are the situations you found yourself in when you object. This is the thing. You have an agreement, and I'm trying to get you as close to your agreement, keeping your child's best interest in mind and at heart. But you know what? But that's a situation that you all put yourselves in when you introduce this person at this school. So I think that's good, right, just and in your child's best interest. But I see the difficulty of the situation and I acknowledge it.
So the court's just gonna delineate on the decree, correct? And sign
Yes.
it? Okay,
Yes.
perfect. Thank you, Judge.
Doing that now. File number 2025 FLA 799C3. The court hereby adopts and approves the agreement of the parties in full. The court finds that it has jurisdiction. And the court reaffirms the previous pronunciation and rendering that was on the record. With regard to the only objection, page 25 of the agreed final decree of divorce, clause A, the court has stricken out certain portions and has, in each of the two sentences, written in an asterisk that both parties are prohibited from introducing the minor children to any person, so on and so forth. And what the court has written in until September 8th, 2026, or until further orders of the court. It is pronounced and rendered. The court has signed an original. Court is tendering that original to the clerk's office. Final time, Mr. Garcia, thoughts, comments, questions, or objections?
No, Your Honor.
Same question, Ms. Escoto?
No, Judge, the only thing pending is the special warranty deed, Mr. Garcia, if I can get that today, since it was due on the day the court signed the decree as well.
I'll have my client sign off on it, Your Honor.
Same question, Ms. Garcia?
Nothing, Your Honor.
Mr. Castillo, do you have any questions for the court?
No, sir.
I wish you, Ms. Hustle, well. More importantly, I wish your two kids all the best. Good luck.
One last thing, Judge, if Mr. Garcia can file a termination of the child support so that his client doesn't get deducted the child support for February.
Any objection?
No, Your Honor.
These are the orders of the court, and those orders are due on or before.
September 23rd at noon by submission.
I'm sorry.
Okay.
What? When?
February the 23rd.
So ordered. All right. Thank you, Mr. Castillo. Have a great day.
Next case from Mrs. Cotto, same page, number 10.
Irma Ramirez versus Ismael Ramirez Jr., cause number 2025 FLA 929C3. Court marks Ms. Escoto, present and participating by video conference. Ms. Elisa Mar Soto, present and participating by video conference. Ms. Leticia Garcia, present and participating by video conference. Irma Ramirez, Ismael Ramirez. Any parties present? Court finds no parties are present. Counsel, go ahead.
Judge, we filed an agreed continuance. Ms. Garcia has been working really closely with the parties. We've exchanged inventories. So what's pending is her final recommendation so that we can incorporate it into a final offer of settlement.
Ms.
That's correct, Your Honor. That's correct.
and Ms. Garcia.
Judge, that's correct. I've spoken to all the parties and the children, but something came up based on my conversation with the children, and I need to redo some interviews with parents. So
Ms. Flores, tell us the next setting, and then I'll ask if there's any objections to that setting. Go ahead.
Next available, Your Honor, will be March 5th at 9.
Objections, if any, Mrs. Cotto?
I should, that's a Thursday. That's fine, Judge. I have court in your court anyway.
Ms. Soto, same question?
At 9 a.m., correct, Your Honor?
Yes, ma'am.
No objections to that date.
And Ms. Garcia?
that's fine with me, Judge.
Thank you all. Very good. Ms. Flores?
March 5th at 9 a.m.
Yeah, right. Next case, please.
Next case, that is all for attorneys Leticia Garcia and Elisa Mar Soto.
Your Honor, I've got one more case. I'm just coming in. It's brand new.
I do too. I have a couple
No,
of
for
more.
Mrs. Cotto, that'll be page 5, number 12.
But you said none for Ms. Soto?
None for Ms. Soto,
All
correct.
right. Have a great day, Ms. Soto. Great to see you.
Judge,
Ms. Flores? Did you say 512?
Yes, Your Honor, page 5, number 12.
Joshua Sass versus Cynthia Pacheco Martinez, cause number 2025 FLA 1305C3. Court marks Mrs. Cotto present, participating by video conference. Are you Cynthia Pacheco Martinez?
Yes, I am, Your Honor.
Welcome to court, Ms. Pacheco. The court marks you present, participating by video conference. As you can see and hear from your device, so is your lawyer. Speak to the microphone, sir, and tell the court, are you Joshua Sass?
Yes, sir.
Welcome to court, Mr. Sass. The court marks you present in person. Mr. Sass, do you have a lawyer?
No, sir.
Will you be going forward without a lawyer?
Yes, sir.
Court marks you self-represented. Ms. Cotto, go ahead.
Judge, I had reached out to Mr. Sass for him to provide me his W-2 and pay stub this morning at around 8:30. I just got a pay stub, but I'm missing his W-2. I'm asking the court to give him an opportunity to send that to me. And then number 2, I did send him an offer of settlement subject to the disclosure of his earnings. And he advises he's not in agreement. So we just need to set this up for a full-blown hearing.
Ms. Cotto, tell the court, and I'll ask for a follow-up momentarily, Mr. Sass, but the portion, I missed it. The portion that was not agreed to was an amount.
He doesn't say, he didn't say, Judge. The email basically says I'm not in agreement.
Understood. Before I ask Mr. Sass, let me see if I can get some background facts, Ms. Cotto, so I can get confirmation. Mrs. Cotto, how many children, if any, before the court?
Just one, Judge.
Age?
I believe she's 1.
And she, so gender female?
Yes, Judge.
Mr. Sass, is that true? You have a 1-year-old daughter with Ms. Pacheco?
Yes, sir. She's 13 months and 2 weeks.
All right. Anything under 24 months is registered by months. Well taken. Mr. Sass, because there's a child involved in this case, it becomes necessary for the court to order one party to pay child support. And in order for the court to do that, the court needs to receive, review, and consider wage information. Anything else that the court does, I mean, it's going to be a guess, speculation, complete speculation and conjecture, whether it's $1 or $1,000. It's just, it has to be very specific. So what Mrs. Cotto here is asking is that you turn over wage information to her. Now, under the policy of well, the statutes of the state of Texas, but under the local rules, that exchange should have already happened. What needs to be exchanged is income tax information, W-2s, 1099s, and pay stubs. Do you have any objection to the court ordering that at some point in the near future?
I advised Mrs. Cotto this morning via email that the W-2 would be available January 29th. That's through the app Workday that my former employer uses. So that's has nothing. I mean, on January 29th, my W-2 will be accessible.
So this would be tomorrow.
Correct. Yes, sir.
All right. So there is no objection to the tendering of the W-2. It's just the timing that's the issue.
Right. My company.
Okay.
It's not going to be available until January 29th.
I understand. So that's the W-2. Mr. Sass, have you completed? Well, ostensibly the answer is no if you don't have your W-2. Have you completed your 2025 income tax?
Negative, sir. Waiting on the W-2.
Right. And do you have the last 3 months of your pay stubs?
I do. She asked me via email for just my last paycheck stub.
Well, that's what she's asking, but since you didn't do that, I now need to do an order, and this court does 3 months. So I'm going to ask you one more time. Now it doesn't matter what she said. The court's about to render an order. So do you have 3 months of pay stubs?
Yes, sir.
All right. Can you give that to Mrs. Cotto?
Absolutely.
How much time do you think would be reasonable and necessary?
End of day today.
End of the day today. And this would be a physical delivery or an electronic submission? Electronic. So I tell you what, let me give you until the end of the day tomorrow. So I'm going to give you more time so that you can compile whatever information you need. And quite frankly, that way you can send all of that together with your W-2 all together. You don't have to piecemeal it if you don't want. So the court is going to order the W-2 and 3 months worth of pay stubs due on or before January 30th by 5 p.m. Now, what you told the court earlier is that there are things out of your control. You don't control when your employer submits these things to you. If that's an issue, because things are out of your control, right? If there's any issues, put that in writing to Mrs. Cotto so that there's full disclosure.
Right.
And that way, as long as there's open communication, this is going to go much more smooth. Mr. Sass, do you have any questions for the court?
So I was just confused about one thing. So I've received 2 letters in the mail from the Attorney General's office where child support has already been deducted. So as of my last paycheck, it reflects $168 being deducted from my paychecks already. The letters from the Attorney General's office state that it's $200.12 a week that will be deducted from my paycheck. However, per federal law, they can't take more than half of my paycheck for child support. So $168.12 went to my oldest 2 daughters from my first marriage, and then $168.12 went to this child support as well. And my last paycheck.
Let me get that on the record, and if there's no objection, and it should be factual. Mr. Sass, would you raise your right hand?
Yes, sir.
Do you solemnly swear or affirm that the testimony you will provide in this case will be the truth, so help you God?
Yes, sir.
You may lower your hand. Is your true and correct name Joshua Sass?
Yes, sir.
Mr. Sass, besides this 1-year-old daughter that you have with Ms. Pacheco, do you have any other children?
Yes, sir. 2.
You have 2 other children. What are their ages?
16 and 14.
Are you responsible for child support payments to those 2 children?
Yes, sir.
How much do you pay for those 2 children?
So prior to this last paycheck, it was $185.72 a week.
All right. I do that just to get through this as soon as possible. Mrs. Cotto, I'm going to stop right there, and you can follow up.
Just really quickly, Judge, there are temporary orders in this case. When Juan Garcia was his attorney, credits were given for those 2 children, and the child support was $765 beginning October the 15th and monthly thereafter until further orders of the court.
Right.
There's an employer withholding that has been issued.
Well taken. I just want to make sure that all of that is, and I know it's in writing, I just want to make sure that it's also on the record. So we're going to come back for a final hearing on trial on the merits on
March 5th at 9 a.m.
Ms. Flores. Does the court have Mr. Sass's email address?
Yes, but if you can just please confirm that email.
What is your email address, Mr. Sass?
It's going to be sass.jas@gmail.com.
You spell that out, please.
SASS.JAS@gmail.com.
Thank you. Did you get that? And you have that, Mrs. Cotto, too?
Yes, Judge, that's where I've been communicating with him. The only thing I'm gonna ask, Judge, if he's also contesting the just and right division of the estate, then I'd ask the court to give him a deadline to submit his inventory.
Mr. Sass. Well, so what's good for one is good for all. So before I ask questions of Mr. Sass, has something similar been done by Ms. Pacheco?
No, Judge, I need to do mine as well. Because
So before I ask one side, tell the court, Mrs. Cotto, should it become contested, how much time would be reasonable and necessary? Knowing that you're coming back on March the 5th.
I'll have it by next week, Judge. That would be February the 6th.
I'm going to give you this scheduling order, Mrs. Cotto and Mr. Sass. And I know that Mrs. Cotto can do this much sooner, but ostensibly, but what needs to happen first is that, Mr. Sass, that you accept or reject any offer made by Mrs. Cotto. So I'm gonna. These are not hard deadline. These are guidelines with a deadline at the end. I suggest, Mr. Sass, that you receive and review the proposal, if any, made by Ms. Pacheco by February the 6th, right? Because I can have you all exchange inventories, but if you agree, you're going to waste all this time doing the inventory when you already have an agreement. So I'd rather you make this as short and as painless and as seamless as possible. So exchange whatever information and proposals you want by February the 6th. And then I think it would be reasonable, Mr. Sass, that you either accept or reject it by February the 13th. If you reject, then you should exchange inventories. Here's the deadline. All of that are guidelines. Here's the orders. Inventories must be exchanged if there is no agreement by February the 20th. But start now, right? Because don't wait until the 19th to start working. You should start working on it right now. And that's a full disclosure of all of your income, earnings, assets, debts, cars, retirement, Mrs. Cotto is going to do the same thing. What's good for one is good for all. But you don't have to worry about any of that if you get to an agreement, right? So one more time, get your proposals sent out, received, reviewed February the 6th. You'll have a week to think about that. On February the 13th, accept or reject, and then you'll have a week to prepare your inventory if you don't. If you don't, that gives you sufficient time to review that and prepare for your final hearing so that this court can then make a just and right division as to your property on March the 5th at 2. Do you have any questions for the court, Mr. Sass?
Just for clarification, inventory is going to be paycheck stubs, W-2, monthly budget.
It's a full disclosure of all of your assets.
Okay, which would be cars, houses, anything, businesses.
That's exactly right.
Okay, right.
Yeah.
And then for further clarification, so the money that's already being deducted from my paychecks right now, that's going to continue happening until March 5th, or
that's right.
Okay, yeah, that's fine. I want to not get.
It's a good question.
Yes,
yeah. All right. You have any other questions?
No, sir. That's it.
Mrs. Cotto?
Nothing further, Judge. If he could just use the Texas Family Law Practice Manual inventory format, just to make life easier, I think, for the court and myself.
Right.
Yeah, there's resources. Do you know, Mrs. Cotto, I know you mentioned the manual. Do you know if lawhelp.org
I can send him one, Judge. I'll do it as a courtesy to the court.
There's forms that you can just fill out that has all the information necessary and required. So just fill out the form and send it back to Mrs. Cotto. And she's going to do something very similar in her own format, but the same style back to you.
Okay.
If there's no agreement. All right, Ms. Pacheco, unmute your device. And tell the court if you have any questions.
I don't have any questions, sir.
All right. I wish you well. Keep in contact with your lawyer. Ms. Flores, anything else on this case?
No, Your Honor.
All right. I wish you well, Mr. Sass. I wish you well, Ms. Pacheco. Have a good day.
Thanks, sir.
Next case from Mrs. Cotto, page 7, number 19.
Maria Teresa Cadena versus Rolando Cadena, cause number 2025 FLB 1347C3. Court marks Mrs. Cotto present and participating by video conference. Ms. Anderson present and participating by video conference as well. Unmute your device, please, and tell the court, are you Maria Teresa Cadena?
Yes, I am.
Welcome to court, Ms. Cadena. The court marks you present. You're participating by video conference, as is your lawyer, as you can see and hear from your device. Rolando Cadena, are you present?
Mr. Cadena is not present, Judge.
So noted. Counsel, go ahead.
Your Honor, Brenda Anderson present for Ms. Cadena. I did file a motion for continuance in this case. We have exchanged inventories. However, I am requesting additional documentation from respondent. So I did serve him with some requests, I believe yesterday or 2 days ago. So we are asking for more time so that we could get that documentation, as well as so we can have an opportunity to try to see if we can resolve this matter, Judge.
Yeah, so I was served with the discovery yesterday, Judge, and I don't have a problem. I already gave the discovery request to my client. He's going to try to get those to me by next week. In the meantime, there is no objection to the continuance based on the request being made. Number 2, we have also agreed that the marital residence will be placed on the market with Martha Wright Martinez, that the parties sign the listing agreement by next week, Judge, and that they agree on a agreed price, but no less than fair market value. And if we don't have an agreement by the end of this case, we'll put the monies into the registry of the court in an interest-bearing account. And we're going to put this in a Rule 11 agreement. Ms. Anderson and I conferred this morning, so just for the ease of court.
Yes, Your Honor, that is correct.
All right, well taken, so ordered and granted. The only concern I have, I think Ms. Flores is about to give us a date very close to 30 days, and if discovery was sent out, even if it's produced before, it's not due. Any thoughts on that, Mrs. Cotto?
If I can get that March 5th date, Judge, I'm okay with getting it to Ms. Anderson sooner.
Is that date available, Ms. Flores?
Yes, Your Honor.
Your Honor, if we could possibly convert that date into a final pretrial, just because in the event that I don't receive the necessary documentation from respondent, I do anticipate having to possibly subpoena previous employers. So depending on what I get back, then I may need to do that. So I would hate to do another motion for continuance.
What she's talking about, Judge, is the retirement information, and I actually got the packet today. So I'm gonna say she'll have it, Judge. But if you want to put that one up maybe as a final pretrial / final hearing in case we do resolve it. And we've also discussed going to mediation with Judge Hale as well.
Yes, Judge. We've just, yes.
Without objection, so ordered. March 5th at
9 a.m.
is the final pretrial hearing. You're welcome to settle and announce the court that settlement on that day. If you unfortunately don't, give us a final hearing thereafter.
April 2nd at 2 p.m. I'm sorry, April the 2nd at 9 a.m.
So ordered. Ms. Cadena, do you have any questions for the court?
No, I don't, Your Honor.
Keep in contact with your lawyer. Mr. Cadena will do the same thing. I wish you both very well.
Thank you, Judge. And that's all I have, Judge. May I be excused?
Great
And
to
my
see you,
client?
counsel. Have a good day.
Thank you.
Mrs. Cotto, page 10, number 28.
Juan Arellano Jr. versus Emily Arellano, cause number 2026, FLB 22C3. Court marks Mrs. Cotto present by video conference. Mr. Andres Reyes, are you present? Court finds counsel is not present in person, not present by video conference. Juan Arellano, Emily Arellano. Any party present? Court finds neither party is present in person or by video conference. Ms. Escoto.
Judge, I'm pleased to announce that we filed with the court a Rule 11 agreement with all of the terms for the temporary orders, including a temporary mutual injunction. Mr. Reyes and I have signed off on the same. We're asking that the court approve that, and those will be the orders of the court until the final hearing.
Court has received, reviewed, and considered this Rule 11 agreement. Court has signed off on it. They're approved. These temporary orders are due to the court in that form on or before.
February the 23rd at noon by submission.
And then we'll come back for a trial of merits on April the 2nd. Thank you, Mrs. Cotton.
Thank you, Judge.
And I think you have a case on recall
Yes.
with Mr. Hernandez. Have you had an opportunity to confer?
Yes, Judge, we're waiting. Judge Hale just sent us some dates, so we're trying to narrow it, but I saw that he was in here and then he stepped out. So I'll call him on his cell.
All right.
Thank you, Judge.
All right. We'll call that case momentarily. Ms. Flores, pause for 1 second.
Yes, sir.
Ms. Flores, would you call the next case, please?
Yes, sir. That will be Attorney Rudy Santos, page 2, numbers 4 and 5.
These are companion cases. Gregory Downing versus Suellen Wentworth O'Neill. Cause numbers are 2023 FLB 361C3 and 2024 FLK 1176C3. Court marks Mr. Santos present and participating by video conference. Ms. Gale, are you here on behalf of Mr. Downing?
Yes, Judge.
Court marks you present. You're participating by video conference. Gregory Downing, Suellen Wentworth O'Neill. Are any parties present?
My client is not, Judge.
Court marks neither party present in person or by video conference. Counsel, what is the announcement, if any?
Judge, yesterday we filed the amended quadro that's been signed by all parties and we presented for the court for signature.
Mr. Santos?
That's correct, Your Honor. We're asking that the court sign off on that quadro.
Court has received, reviewed, and considered that amended qualified domestic relations order signed by both parties. It is agreed to, the court has signed it. The court is tendering the original signed signature copy to the clerk's office. Counsel, is there anything remaining on these cases?
There is not, Your Honor.
Okay, that concludes these cases, and the court will ask the clerk's office to mark these as closed or disposed.
Thank you, Judge.
All right, good to see. Any other cases for either counsel?
No, Your Honor.
Good to see you both. Have a great day.
You too,
Thank you,
Judge.
Your Honor.
Next case, page 8, number 22, with Attorney Juan Jose Garcia.
Luis Antonio Estemera versus Hilda Rivas, cause number 2025 FLC 1065C3. Court marks Mr. Juan Garcia, President participating by video conference. Philip Del Rio, Counsel Del Rio, are you present? Court finds Counsel Del Rio not present. Luis Antonio Estemera, Hilda Rivas. Any parties present? Court finds no parties are present. Mr. Garcia?
In this case, Your Honor, we submitted a Rule 11 agreement, and I did submit also some temporary orders, Your Honor. I did send them to Mr. Del Rio. He just told me to e-file them. But on the temporary orders, it just it follows exactly what was said in the Rule 11, Your Honor.
Court has received, reviewed, and considered these temporary orders consistent with the court's previous hearings. The court has signed off on them. And now we will proceed to a petition on the motion to modify on March the 5th at 2 p.m. Anything else on this case?
No, Your Honor.
Thank you, Mr. Garcia. Ms. Flores?
That is all for Mr. Garcia.
It's good to see you, Mr. Garcia. Have a great day.
Same here, Judge. Thank you, you too.
Next case would be Attorney Nathan Chu, page 9, number 25.
Samantha Lee Ramos. This is in the interest of Samantha Lee Ramos. Cause number 2025 FLK 99C3. Good morning, Mr. Chu.
Good morning, Judge. Nathan Chu, present for Ms. Ramos. This is a petition to change the name of the child, Judge.
Court martial present by video conference. Ms. Ramos, I'm going to ask that you unmute your device. Are you Samantha Lee Ramos?
Yes.
Welcome to court, Ms. Ramos. Court martial present by video conference. As you can see and hear from your device. Your lawyer is also present by video conference. Mr. Chu, what is the announcement?
Judge, we're ready to proceed, Your Honor.
I guess before we do, in review of this case, the court didn't see any service as to father. Mr. Chu, has service been effectuated or perfected on dad?
Judge, we had to do a citation by posting that was issued back in November 25th of 2025.
Apologize to you. I didn't catch that. Let me just confirm and put that on the record. Let me do two things. I will look and confirm, and let me ask the clerk's office to do the same thing.
Your Honor, we don't have a return on file, Your Honor.
That's why the court didn't catch it. You may have it, but it's not part of the record.
Not a problem, Judge. We can just have a reset until we get the return on file, Your Honor.
Sure. Ms. Flores, give us that setting. Ostensibly, it shouldn't be too long if it's just a matter of filing.
March 5th at 9 a.m.
Thoughts, comments, or objections, Mr. Chu?
No objection, Judge. Thank you.
All right, so ordered. Ms. Ramos, so it's a procedural thing, and it may sound minor, but it's important because anytime the court makes a decision, we need to make sure that we comply with all the requirements and that we only have to do it once without anybody being able to object to having done it wrong. So we just want to do it once and do it once right. So we'll come back on March the 5th at 9. Ms. Ramos, do you have any questions for the court?
No. Thank
I
you.
wish you well. Keep in contact with your lawyer.
Next case from Mr. Chu, that'll be page 10, number 27.
Itamari Lopez versus Nahum Lopez, cause number 2025 FLA 68C3. Court marks Mr. Chu present by video conference. Speak into your device microphone and tell the court, are you Itamari Lopez?
I am.
Welcome to court. The court marks you present. You're participating by video conference. Are you Nahum Lopez?
I am.
Welcome to court, Mr. Lopez. The court marks you present in person. Mr. Lopez, do you have a lawyer?
No.
Are you going forward without a lawyer?
Yes.
The court marks you self-represented. Mr. Chu, go ahead.
Judge, we had just served Mr. Lopez on January 23rd, Your Honor. I guess if we can just have another 14 days, that way he'll get a chance to get ready for this hearing, and I'll get a chance to chat with him if he doesn't want to proceed with the lawyer, Judge.
Sure. Ms. Flores, does the court have Mr. Lopez's email address?
No, Your Honor.
Mr. Lopez, what is your email address?
It's njr081412@gmail.com.
Say that one more time in case we missed it.
njr081412@gmail.com.
Did you get that, Ms. Flores?
Yes, Your Honor.
All right, so be on the lookout in your emails, Mr. Lopez. If the court needs to send you any information, send you any notices, it'll go to that email address, and that's the email address that Mr. Chu can do the same thing. Give us a temporary orders date, Ms. Flores.
February the 10th at 2 p.m.
And so I'm going to hear this case. Now, between now and then, Mr. Lopez, communicate with Mr. Chu if that's what you want to do. And yeah, all you have to do is hear him out, and he's going to make you a proposal, and you can agree to some of that, all of that, none of that, anything that you don't agree with. I will make a decision after hearing from Ms. Lopez under oath and hearing from you under oath. You understand all of this, Mr. Lopez?
Yes, Your Honor.
Do you have any questions for me?
No.
Ms. Lopez, unmute your device and let me know if you have any questions.
No, I don't.
All right. I wish you both well. We'll see you on February the 10th. Good luck.
Thank you.
Thank you, Judge.
That is all from Mr. Chu.
It's good to see you, Mr. Chu. Have a great day.
Have a good day, Judge. Bye-bye.
Thanks.
Next case is Attorney Leticia Garcia, page 8, number 21.
Good morning again, Judge.
Good morning. This is Valentin
afternoon.
Palomares versus Sandra Leticia Palomares, cause number 2025 FLB 1582C3. Ms. Garcia, you're making an appearance for respondent.
I am, Your Honor.
Welcome to court once more. The court marks you present participating by video conference. Mr. Del Barrio, are you present?
Present, Your Honor.
Thank you, Mr. Del Barrio. Court marks you present participating by video conference. Valentin Palomares, Sandra Leticia Palomares. Any other person present on this case? Is this your client, Ms. Garcia?
It is, Judge.
All right. Welcome to court, Ms. Palomares. The court marks you present by video conference from the office of your lawyer. Mr. Palomares is not present. This is a first setting. Counsel, what is the announcement?
Your Honor, if we can have a reset date or at least for temporary orders, I have to file my pleadings. She was only served on the 14th of this month, so we still have some time left to file. So I guess once there might be a chance that Mr. Del Barrio prior to that time, I've got some options based on what my client has told me. So if Mr. Del Barrio, what do you want to do? Do you want to get a date now?
We can get a date now. I'm okay with that. I mean, I know,
Okay, let's
I
do
know
that.
you just came on, so I'm okay with it, but hopefully it should be something that we should be able to resolve rather
Right.
quickly. And Mr. Palomares was on, Your Honor. I think he just called the office that his phone ran out of battery and he was running out of battery, but I knew we were gonna reset. So either way, if the court's willing to give us a date now, I'm pretty sure we can
Yeah,
work.
let's do that.
Well taken on all fronts. Just one observation. That's why this court's local rule says if you're going to log on remotely from a device, make sure it's connected to a power source. Happens all the time. But well taken and understood. Ms. Flores, give us 2 dates, temporary orders and final hearing date, please.
Yes, Your Honor. Temporary orders will be February the 10th at 2 p.m. and final hearing March 31st at 2 p.m.
All right. I wish all persons well. We'll call those case on those dates. Anything else on this case, Mr. Del Barrio?
No, Your Honor, not on our behalf.
Ms. Garcia.
Nothing, Judge. Thank you.
Any other cases for either?
No,
And
Your Honor.
I apologize. What was the second date? I know it was February 10th and March, what?
31st. at
31st.
2
Okay,
p.m.
perfect. Thank you.
Ms. Garcia, Mr. Del Barrio, always good to see you both. Have a great
Thank
day.
you, Judge. You have a great day. That's all I have. Thank you.
Thank you.
Next case is Attorney Alberto Martinez King, page 4, number 11.
Carlos Misael Gloria versus Wendy Anaí Gloria on cause number 2025 FLA 1213C3. Good morning, Mr. King. Well, I should say good afternoon at this point. Good afternoon, Mr. King. Mr. King is not available. Call the next case.
That'll be Attorney Victor Villafranca, page 4, number 11.
That is the same case.
Yes, Your Honor. Good afternoon.
Give us, Mr. Martinez King isn't available. Give us 1 second. Any other cases for Mr. Villafranca?
Page 8, number 23.
Mario Alberto Valadez Jr. versus Jocelyn Ventura, cause number 2025 FLI 276C3. Court marks Mr. Villafranca present by video conference. Mario Castillo III, are you present? Court marks Mr. Castillo not present. Mr. Jonathan Garcia Davalos, Mario Valadez, Jocelyn Ventura. Any other person present? Court finds no other person is present. I think Ms. Catherine Garcia may be present. Mr. Villafranca, what is the announcement?
Your Honor, we filed an agreed motion for continuance in this case. We received the ad litem report 2 days ago. Counsel and I have both agreed that we need a little more time to review the report of the ad litem. It looks like we're going to come to the agreement and go on the recommendation from what I understand right now. We just need time to review it with our clients and come to the agreement, Judge. That's the most likely outcome. Both counsel and I have spoken. We are requesting 14 days, Judge, to get this case disposed of.
Mr. Villafranca, you know the question that the AG's office is going to ask, any of this agreement touches on support issues?
They did have a support issue, Judge, that I mean, I guess I'll leave that up to them. So I believe it's in their pleadings, not ours.
Well, the reason I say, because if it does, and I give you a setting at any point and you don't disclose it to the AG's office, they're going to blow through that setting because it wasn't disclosed to them. So I would rather full disclosure now so that you have one setting that doesn't.
You know what, Judge, if they're still going forward on child support issues, we would be contesting it. So it's very possible that issue would be contested. I'm not sure. I don't think we're going to be contesting the custody and visitation.
Well, so the continuance is, let me hear from Ms. Garcia before I do. Ms. Garcia, anything to put on the record?
Your Honor, I just showed that this was an original AG filing. We did plead for all issues to be determined. We are going to be requesting child support be set and medical support and dental support to be addressed. I don't know what the parties' agreement was at this time, but we're not opposed to a continuance.
For all those reasons, the request is well taken. Ms. Flores, just give us the next setting, whatever that is. It may be contested.
March 5th at 9 a.m.
All right. So please just disclose whatever agreement there could be or maybe or will be to the AG's office. That way they know whether they're going to contest, and they can also advise the parties whether it's going to be contested or not. So,
yes, Your Honor.
Thank you for keeping in contact with Mr. Castillo. Any other cases for Mr. Villafranca?
No, yes, sir. Well,
Oh.
the one with, yes, page 4, number 11.
Mr. Martinez King, are you available? Court sees the device is logged on. Let's call that case because this is Mr. Villafranca's last.
Page 4, number 11. Your Honor.
Carlos Misael Gloria versus Wendy Ana E. Gloria, cause number 2025 FLA 1213C3. Court marks Mr. Villafranca present and participating by video conference. Mr. Martinez King, device is logged in. Carlos Gloria, Wendy Gloria. Any party present? Court finds no parties present. Mr. Villafranca?
Your Honor, we're just set for a pre-trial. We have sent over a proposal to counsel. We're looking at that, Your Honor. I guess we could just keep it for the next setting, Judge. I believe it was the 12th or the 13th. I'm not sure. The final pre-trial, or I'm sorry, the final hearing.
Yes, sir. This case is set for February 12th at 9 a.m. Are you Wendy Gloria?
Sí, soy Wendy Gloria.
Welcome to court, Ms. Gloria. The court heard that there's nothing for the court to consider at this hearing.
El juzgado ha escuchado que no hay nada que considerar esta mañana.
So the very next hearing will be the final hearing
Entonces la siguiente audiencia va a ser la audiencia final.
on February the 12th, 2026
En febrero 12, 2026,
at 9 a.m.
a las 9 de la mañana.
Ms. Gloria, do you have any questions for the court?
Señora Gloria, ¿tiene alguna pregunta para el juzgado?
No sé qué podría preguntar, la verdad.
No, I don't know what I would have to ask.
Which means there's no questions.
Eso significa que no hay pregunta.
Keep in contact with your lawyer
Manténgase en contacto con su abogado
and we'll see you on February the 12th.
y la vemos en febrero 12.
I wish both you and Mr. Gloria well. Have a
Le
good day.
deseo lo mejor a usted y al señor Gloria. Que tenga
Gracias.
That's all I have. I'm excused.
Yes, sir. Good to see you and Mr. Martinez King.
Next case, Your Honor, page 6, number 16, with Attorney Norberto Carden.
Mayra Lilia White, Michael White II, cause number 2025 FLA 1596C3. Court marks Mr. Cardenas. Is Mr.
I'm
Cardenas?
present. I'm present, Your Honor. I'm just parking. I had to leave my office. I've been logged on, but I had to leave my office. Give me a second. I'm sorry.
All right, court marks Mr. Cardenas present by video conference. Mr. Santos, are you still present? Court finds Mr. Santos not present. Are you?
Yeah. Your Honor, Mr. Santos was present earlier. The court just had a couple of cases with him. We still have this one case pending.
Your Honor, he is in the waiting room admitting.
Please, court staff will now admit Mr. Santos. Court marks him present and participating by video conference. Unmute your device and tell the court, are you Mayra Lilia White?
Yes, Your Honor.
Welcome to court, Ms. White. The court marks you present, participating by video conference. As you can see and hear from your device, so is your lawyer, Michael White II. Are you present? Court finds respondent White not present. Mr. Cardenas, Mr. Santos, go ahead.
Your Honor, we have reached an agreement in this case. It's a simple divorce. All parties have signed off, attorneys and the parties. We've submitted a proposed divorce decree earlier today in the court file. We just asked that the court sign off on that decree and grant the divorce, Judge.
Mr. Santos?
Your Honor, that's correct.
All right, Mr. Cardenas, anything else to put on the record?
No, Your Honor.
Mr. Santos?
Nothing with regard to this matter, Your Honor.
Ms. White, would you raise your right hand, please? Do you solemnly swear or affirm that the testimony you will give in this cause will be the truth so help you God?
Yes,
You may lower your hand. Is your true and correct name Mayra Lilia White?
correct. Yes,
Ms. White, you filed this divorce November 7, 2025. On that date, had you lived in Texas for 6 months?
correct. Yes,
Had you lived in Webb County for 90 days?
yes.
Are you currently married?
No.
You're asking for divorce. Are you currently married right now?
Oh, yes.
All right. What's the name of your husband?
Michael Wesley White.
When did you enter into marriage?
2013, December.
And when did you stop living together as husband and wife?
November 2023.
Has your marriage become insupportable?
Yes, Your Honor.
Is there any possibility of reconciliation?
No.
Right. Your lawyer and your husband's lawyer have submitted to the court a final decree of divorce. Do you believe that this agreement that you have with him is a just and right division of your property?
Yes.
You have a child with Mr. White, and you have an agreement regarding everything regarding that child. Do you believe that that agreement that you have with Mr. White is in the best interest of your daughter?
Correct. Yes.
Are you asking for a name change?
Yes, I am.
To what name?
Mayra Lilia Garcia.
Anything else you want to tell the court, Ms. Garcia?
No, Your Honor.
Ms. Catherine Garcia, there was a child support review order in the 2015 case. Anything for the record?
Yes, Your Honor, and this is the correct White case. There is a SAPSR cause, and there are current orders in that case, 2024 modification order. That cause number is 2015 CVW 001741C3. We would just ask one that the court note in the decree that that cause has been consolidated into the divorce cause number. And then secondly, if the I don't know if the child support obligation has been changed or the medical support terms have been changed, or if the decree adopts the obligations from the prior order. But we would want to make sure that the proper medical support is addressed in the final decree.
Response,
With
Mr. Cardenas?
respect to the cash medical support, I believe it's addressed on page 21 of the proposed decree. It's set at $60 per month.
And that mother is ordered to continue to enroll the child in government health insurance and dental?
That's correct.
Okay, and then the AG's office is fine with that, Your Honor.
To the AG's office, second question, what about child support? Was child support modified in any way?
Your Honor, I don't know if it was modified, but the agreement of the parties based on the income information was, I believe it was set at $416 or $418.
And that's fine. The current order in place that we have is $413.
I think that might be correct.
All right, and Ms. Garcia, what was the first point that you raised was that the underlying review case was consolidated, or are you asking that it be consolidated?
I'm asking that the final divorce decree clearly note in the decree that the prior SAPSR cause, the 2015 cause number, the court would order that to be consolidated into the divorce cause.
Any objection to that request, Mr. Cardenas?
No, Your Honor, no objection. We mentioned the cause number in the petition, Judge. That 2015 case, I believe we had asked that it be consolidated or put together. I don't believe we put it in the decree though, but we're okay with it being written in there, or if the court wants a new decree, we can get a new one in.
Mr. Santos, objection?
We have no objection, Your Honor, especially if the court were to interlineate something to get this over efficiently.
I appreciate all. Thank you. Good request all the way around. Ms. White, in your case, cause number 2025 FLA 1596C3, the court at this time finds that it has jurisdiction over your case, meaning this is the proper court form and venue to consider a divorce. The court finds that you entered into marriage with Mr. White in December of 2013, but you stopped living together as husband and wife in November of 2023. The court finds that you had one child, a daughter, that was born in the marriage. No other children were born, adopted, or are expected. The court finds that you have an agreement with Mr. White regarding everything involving your daughter. The court hereby adopts and approves that agreement and finds that it is in her best interest. The court finds that you have an agreement regarding the division of your property. The court hereby adopts and approves that agreement and finds that your agreement is a just and right division. The court hereby changes your name to Mayra Lilia Garcia. And at this time, Ms. Garcia, the court finds that there is no reasonable expectation of reconciliation, and the court hereby renders and pronounces you divorced. I have written clearly on the bottom of page 1 in an asterisk, cause number 2015 CVW 001741C3 is consolidated with this cause. It is so ordered. I have signed it, and I have signed the final decree of divorce, and I'm tendering the original signed version to the clerk's office. Ms. Garcia, do you have any questions? Ms. Mayra Lilia Garcia, do you have any questions for the court?
No, Your Honor.
All right, anything else on this case, Mr. Cardenas?
No, thank you very much, Your Honor.
Mr. Santos?
Not on this case, Your Honor.
Ms. Catherine Garcia?
No, Your Honor.
Thank you all. Have a great day.
You judge.
And Your Honor, AG's office has no further business before the court. May I be excused?
Thank you so much for your service, Ms. Garcia. We appreciate you.
Glad to help.
That is all from Mr. Cardenas.
Great to see you,
Thank
Mr.
you.
Cardenas. Have a great day.
From Mr.
Likewise,
Sa-
Your Honor. Thank you.
Page 6, number 17.
Yesenia Hernandez versus Juan Antonio Hernandez, cause number 2025 FLB 44C3. Court marks Mr. Rodolfo Santos Jr. present and participating by video conference. Andres Reyes, are you present? Court finds Mr. Reyes not present in person, not present by video conference. Are you Yesenia Hernandez?
Yes, Your Honor.
Court marks you present in person. As you can see from this screen, your lawyer is present and participating by video conference. Juan Antonio Hernandez, are you present? Court finds Mr. Hernandez not present in court, not present virtually. Mr. Santos, go ahead.
Your Honor, we're set for trial on the merits, and we informally settled this matter with Mr. Reyes and his client. All matters have been resolved, and we've submitted a proposed decree. We do believe that it is a just and right division with respect to the estate, and if the court would permit, we would ask that we be allowed to prove up the decree.
Yes, sir. Ms. Hernandez, would you raise your right hand, please? Do you solemnly swear or affirm that the testimony you will give in this cause will be the truth, so help you God?
Yes, Your Honor.
You may lower your hand. Mr. Santos, you may proceed.
Can you please say your full name for the record, ma'am?
Yesenia Hernández.
Yesenia Hernández.
Señor juez, antes que empiece, ¿yo puedo comentarle algo?
Your Honor, before we start, can I say something?
Mr. Santos, this is your client and she would like to address the court. What would you like to say before that happens, if
Ms.
any?
Hernandez, I would recommend that you confer with me before addressing the court.
I'll allow you to talk to me because that's what you want, Ms. Hernandez. Your lawyer who's here to represent you, give you legal advice, guide you through this process. He's suggesting that you talk to him before addressing the court. What would you like to do?
Estamos aquí para una decisión final, right?
We are here for a final decision, correct?
This is a final hearing and it is a fifth setting. Yes.
Okay. Abogado, yo necesito mencionar algo.
Attorney, I need to say something.
El día de ayer se me envió una propuesta por mi abogado que
Yesterday, I received a proposal that was sent to me by my attorney.
yo la vi ya muy tarde. En esa propuesta dice que yo me estoy divorciando por causas irreconciliables.
On that proposal, I received it late last night. It says that I'm getting divorced because of irreconcilable circumstances.
Circunstancia que no es así, dado que desde que yo interpuse la demanda de divorcio, viene por adulterio, no causas irreconciliables.
Since I submitted the divorce, it's for adultery, not for irreconcilable circumstances.
Si bien es cierto, tuvimos una mediación en enero 5.
On January 5th, we had a mediation.
Donde el abogado de mi expareja o de mi pareja aún aceptó que él tiene 2 hijas y tiene una otra mujer, circunstancia que he venido yo narrando en todo este año.
And in that meeting, my ex-partner or my current partner stated that he has another partner and 2 daughters. It's something that I have been saying all along.
So, cuando yo leo este acuerdo, hay cosas que no se dijeron en el meeting. Yo quiero, señor juez,
And there, when I read the agreement, there were some things in there that were not talked about during mediation.
yo quiero que el caso salga por adulterio y no causa reconciliable.
I want the case to be done for adultery, not irreconcilable circumstance.
En la mediación no se tocó los gastos del abogado y yo quiero que Juan Antonio pague lo de los honorarios de mi abogado porque él es el que me tiene aquí.
And I want Jose Antonio to pay for my attorney fees because he's the one that has me here.
Mr. Santos, let me ask you this final decree of divorce. 2 questions. First question. It's signed by both counsel. Does this decree contain the agreement of the parties?
It does, Your Honor.
Second question. Is there a mediated settlement agreement signed by both parties?
Not an MSA, Your Honor. It's an informal settlement agreement. I believe it's also been filed of record.
And I have reviewed the proposed agreed to final decree of divorce. There are portions in this divorce that give, I hesitate to use the word disproportionate, but it gives some more money to Ms. Hernandez and it gives some more debt to Mr. Hernandez, ostensibly without knowing more. Were these some things that were considered and contemplated in reaching this agreement?
Yes, Your Honor. It was a concession by opposing counsel, and it was meant to offset the admission.
That's what the court needs to know. So this is what I'm going to do, Ms. Hernandez, because you need to talk to your lawyer. You need to have all of your questions answered. I am satisfied that the work that he has done comports with the agreement. I think it's just a matter of having some questions answered by your lawyer to you that will put you in a good position, because I think you should already be there now. But you have one more date on February the 24th that is for dismissal. So on that date, you will either prove up your case because you are the petitioner, or I will dismiss this case, which your lawyer, one of the many questions that the lawyer will answer for you and will likely advise you on is the fault of the marriage. If the purpose, and that is a legal purpose, to prove fault is for and to gain a disproportionate share, it looks on the face of the agreement that you're already getting there. That may or may not be the case. Confirm that with your lawyer. If the purpose of proving adultery and an affair is just to further strike and rehash pain and to put into legal documents solely for the purpose of having a permanent legal record of the affair, that may not be a good reason. But that is your right. So talk to your lawyer about the facts and about legally what would happen if you prove the affair, because just on the face of the document, you may already be there. I'm going to call your case. And quite frankly, I think all lawyers, when they do their job, the court should put that on the record to avoid any misunderstanding and any complaints in the future. And this is the other thing that I am trying to get you and Mr. Hernandez to a good place, because it sounds like just on the face of the document that everyone has done their job, their role, their representation. And I just want to make sure and confirm that on the date of the final hearing. Do you have any questions for the court, Ms. Hernandez?
No, that's fine, Your Honor.
All right, I'll call this case on February the 24th at 2. I wish you and Mr. Hernandez all the best. Good luck.
Thank you, Your Honor.
Welcome, Mr. Santos.
Have a great day, counsel.
Thank you, Judge. Thank you.
Last case, Your Honor, is a recall, page 7, number 20, with Attorney Scotto and Attorney Hernandez.
Arlene Caldera versus Marcos Caldera, cause number 2025 FLB 1441C3. Court marks Mrs. Scotto present and participating by video conference. Mr. Hernandez, I don't know what buttons you're pushing, but stop. You can't share and stop pushing buttons on this conference Zoom. Court marks Mrs. Scotto present and participating by video conference. Mr. Hernandez, are you present?
Yes. Can you hear me?
Yes.
Can you hear me?
We can hear you. We just can't see you. The court marks your device.
All right.
Logged in. Court, Marcos Caldera, are you present?
He was, Judge, but he may have logged out, Judge.
And court finds Ms. Caldera is no longer present in person. Mr. Hernandez, Mrs. Scotto, go ahead.
So, Judge, I had filed several motions with the court. The first one was a motion to refer this case to mediation. Mr. Hernandez and I conferred this morning, and we had ample opportunity to contact Judge Hale. He's available on February the 10th at 9 a.m. And so we've agreed to go to mediation. We'll just ask the court to sign the order appointing Judge Hale.
Mr. Hernandez?
Yes, that's correct, Judge.
And the second announcement is that then I will abate my motion to modify the temporary orders until after the mediation, in the event that we can't settle.
That's fine, Judge. We'll go ahead and file our responses to that as well.
And finally, Judge, we've agreed that Mr. Hernandez will again advise his client that she cannot have her paramour at the house at 440 General Franco, Laredo, Texas, until further orders of this court, Judge. And his name is Mario Pedraza, whoever it is that she's dating with. My client's the one that's paying for the mortgage, the utilities, and giving her spousal support, Judge. And this person is,
We agreed that that's the case, Judge. I will talk to my client and we'll go ahead and talk to her about it and we're gonna try to get this case as smoothly out of the way as possible.
I wish you, your client, and Mrs. Cotto and her client well and all the best at mediation. It is hereby ordered by agreement, Senior District Judge Oscar J. Held Jr. is hereby appointed as the agreed to mediator in this case. That is going to happen and is hereby ordered by agreement to happen on February the 10th at 9 a.m. And they'll come back on February the 12th at 9 a.m. should there not be an agreement, or you can announce the agreement on the record. Mrs. Cotto, anything else on this case?
no, Judge, just the admonishment that this person not be at the house.
I've always said I was gonna talk to him, Judge.
It is on the record and well taken. Anything else on this case, Mr. Hernandez?
No, Your Honor.
Any other cases for either counsel?
No, Judge, I'm done. And I'm glad we came to the CLE yesterday. A lot of the issues today were from yesterday.
Mr. Hernandez, Mrs. Cotto, it is a beautiful thing when lawyers talk to each other and when judges talk to each other. And I would certainly hope that that continues to be the case in our beloved Webb County. Thank you, Mrs. Cotto. Mr. Hernandez, always good to see you. Have a great day.
You, Judge,
Yes,
you
sir.
stay safe. Thank you. Thank you, Mr. Hernandez.
Yes, sir.
Ms. Flores, have all cases been called on today's docket?
Yes, Your Honor, all cases have been called.
This now concludes this docket held in person and by video conference for Wednesday, January 28th, 2026. The court continues to embrace the latest technology to provide safe and uninterrupted access to justice without delay. Today's docket was made possible by the appearance of counsel and parties and by the assistance, diligence, and preparation of the Webb County Court at Law 2 staff and the employees of Webb County that provide judicial support to the court. The court appreciates and thanks our interpreter, Mr. Cuellar, our district clerk's office, and the sheriff's office for their support and assistance. Court wishes all a good day. Be safe.